Cameras turned off, the campaign has died, but the work we started, it never subsided. From the desert floor to the mountain height, we're shining the torch, we're bringing the light. 17 counties under one big sky, we're watching the records, we're asking them why. Oh, W4Nevada, the people's own desk, putting the truth to the ultimate test. For the school boards, the cities, the local town hall, we're showing up, brother, we're answering the call. From the receipts to the findings, we lay it all down. Accountability in every Nevada town. If the shadows are growing and you need some sun, bring it to us, now the healing's begun. Speak plainly, speak loud, let the truth be heard. We're keeping our promise, we're keeping our word. W4Nevada.com.
That's right.
You know where to go. Call or text that number. Let the power flow. 702-381-4295. Nevada for Nevadans. We're still alive. Power back to the people. Power back to the people.
Get your roller skates ready, Nevada? My favorite part of the song, right here. Welcome back to W4Nevada Live. I'm Matthew Winterhawk, and you are tuning into continuing day coverage afternoon after the lunch recess. Day 16, Coyote Springs LLC versus the state of Nevada in a $1.5 billion, billion with a B, ladies and gentlemen, takings claim. So, how has everything developed? Where did we get to? We put out an update across the web, the interwebs, the web, the interwebs, the what? Make sure you're sharing this out, folks. We have some visibility issues. Hit that little button that says repost. You know, look down here. Look, see this new thing? Ooh, I was working on that in lunch. You probably saw me clicking around and pushing buttons. It's a ticker. We're getting official, folks. Watch out. The news stories and things that are progressing in different PUCN filings and or Department of Water or any filing that you can see across the matrices and or matrix that is development inside the state of Nevada. If it affects Nevadans, we are on top of it. If we missed it, we're also human. At the end of the day, it is what it is. So we will be getting back into this court session. We are due back at 1:15. It is 1:06 p.m. right now. Let's see what we got going in on the update here. I know that we had some issues up in Elko. Is that right? So there was a late breaking. Elko had an air quality alert remaining in effect till 6 p.m. today for Elko, Rendon, Jiggs, Lemoy, Lee, South Fork, and Spring Creek. Particle pollution may reach orange or unhealthy for sensitive groups. Children, older adults, and people with heart or lung conditions should limit prolonged or strenuous outdoor activity today. Stated by the National Weather Service, the forecast uses preliminary Nevada Division of Environmental Protection data that currently from them has not been validated. Now, the fire numbers are currently conflicting. We've got Blue Eagle listed at 6,500 acres, 6,500 is 0% containment in the live incident feed. However, Thursday morning's NIFC report listed Blue Eagle at 4,063 acres. So I'm going to assume that grew 2,437 acres in a very short amount of time. I don't know what kind of wind they're dealing with out there. We're publishing both figures, obviously. The 6,500 that was stated and the 4,063 could just be the difference. Current perimeter, maybe we'll check and reconcile the difference later on today. Excuse me. Sombrero has been adjusted from the morning rounded 20,000 acre estimate to 19,204 acres. Ladies and gentlemen, that is huge. Containment remains at 50%. That reduction appears consistent with the updated mapping. Not a sudden reduction in the fire danger. Red flag warnings and the threat of additional dry lighting continue across portions of the northern and central Nevada today. No new evacuation, injury, or confirmed structure loss reports have been accompanied with these figures that have been updated. Clark County had 3 environmental notices today. The Nevada Department of Environmental Protection opened new public comment periods that are involving the Evenpaw underground water and power line, the NV Energy's Clark Generating Station, and NV Energy's Sun Peak Generating Station. Now, you have until September 28th, until 5 p.m. on the 28th of September to get your public comments in about those 3 items. Funny enough, yesterday we were in a call for about 38 minutes with Nevada Department of Environmental Protection where they were contemplating changing NAC code and administrative changes. So, Story County, Morgan Stanley records today have matched the Capital Group that is seeking a Nevada license to operate a provider as a provider of new electric resources. The same corporate name and address now appear in Story County's September 1st business license packet. Both matters remain pending. The county packet itself does not identify a customer, a facility, a power project, or a reason for the proposed Story County activity. We are not currently connecting Morgan Stanley to a specific mine, data center, or industrial use without the current records to prove it. And today, in the legislature's Government Affairs Committee had began its final work session at around 1 p.m., 9 minutes ago. So W4Nevada is watching the new lightnings starting up north, as we talked about those fires, the Blue Eagle fire, Sombrero fire. There's so many fires right now, ladies and gentlemen. I pray for Northern Nevada and each and every one of you that's affected by it. So, we've got about 5 minutes before we get into this. Once again, you're watching W4Nevada. My name's Matt Winterhawk. 17 counties, not just 2 in a sports book. We the people, we the press. And we will be right back.
You can look me over, see the scars I wear, long road on my shoulders, still I stand right there. I came up through the hard days, dust on my shoes. You kept count of my failures. I kept my truth. And I know what you said with that cool little smile. You can doubt what you want, but I've been here a while. You don't have to believe in was late to the sunrise, still I found my way. Every crack got some gold in it, every bruise could pray. I ain't asking for nothing, just a little respect. If you see what he planted, you might see me next. And I know what you said with that cool little smile. You can doubt what you want, but I've been here a while. You don't have to believe in me. God did. God did. He knew my name before I did. Oh, you don't have to believe in me. God did. God did. He made this hard to take the hit. When the room got colder, he kept me warm. When the world got louder, I stayed informed. So if you can't see it, that don't change the light. He saw me broken and still said right. You don't have to believe in me. God did. God did. He knew my name before I did. Oh, you don't have to believe. Don't have to believe in me. God did. God did. He made this hard to take the hit. Ooh, you don't have to believe. Don't have to believe in me. God did. I'm still the proof that grace exists. Hey, hey, hey.
And you may resume.
Thank you, Your Honor. Housekeeping matter, they would offer proposed exhibit 3302 and 3382.
What's 3382?
2006 multi-party agreement.
Yeah, no objection to either one, no.
Thank you, counsel.
All right, they're admitted.
3302 and 3382.
Yes, thank you. Mr. Whittemore, before we broke, we were talking about that 2006 multi-party agreement. Do you recall that document under discussion?
Yes.
Linda, may I have CSI's exhibit 136, please? And Mr. Whittemore, this is a water rights grant bargain and sale deed, and you can see that it's been recorded in Clark County, and it appears to reflect a transfer from Coyote Springs Investment to the Clark County Coyote Springs Water Resource General Improvement District. Just take a moment to review that document, and you can see at the second page of that, it appears to bear your signature.
Yes, that's my signature.
One of the things you said, sir, with respect to the multi-party agreement is that CSI had to essentially provide water to the GID for the GID to essentially act as a water purveyor.
That's correct.
And this document appears to transfer a portion of permit 70429. You can see in the middle of the paragraph, the first paragraph.
Yes, that's the document which we were discussing earlier today.
It says subject in the bold language in the middle, subject to the restriction and limitation that grantee may only use his water rights to serve or otherwise benefit the Coyote Springs Master Plan Community located in Lincoln County and Clark County, Nevada. And further, if you can highlight the next paragraph, there it is, subject to the restrictions that the water right may only be used within the Coyote Springs Valley hydrographic basin, and the permit terms, conditions, rulings, and orders of the Nevada State Engineer that are on file in the office of the Nevada State Engineer. And that goes on to say, further provided that grantor affirmatively states that the water rights are not subject to any obligation to dedicate the water rights to the United States Fish and Wildlife Service for the benefit of the Dace. Did you understand, sir, that when CSI transferred this to the GID's ability to use that water as the purveyor was constrained by the terms of the permits, rulings, and orders?
Yes,
So to the extent that Las Vegas Valley Water District as a general manager determined that the use of the water that had been granted to the GID violated or otherwise was contrary to the permit terms, conditions, and rulings and orders, do you believe that it had the authority not to disperse that water?
Objection, lacks foundation, calls for legal conclusion.
You can state his understanding.
the deed was drafted in such a way by Carl that I executed on behalf of the company to make it clear that the water purveyor understood that the water rights were limited to the Coyote Springs Valley and that they were further limited to the permit terms and conditions. I don't think that the deed in any way created a multi-party agreement between Coyote Springs and Las Vegas Valley Water District that somehow they were taking over the position of the Nevada State Engineer. I think it was the Nevada State Engineer still had the independent authority to determine, what was going to happen with that water, and that Las Vegas Valley Water would follow those rulings and orders. But I think it's fairly clear on its face that that's what the document does.
I can have CSI 137, please. And this is a document, excuse me, styled Water Rights Grant Bargain and Sale Deed. Again, it's recorded in Clark County. It appears to be a transfer of additional portion of 70429 to the Clark County GID. Does that comport with your reading of the document?
Yes, sir.
You can see on the second page, actually at 004, it appears to have been executed by you. I'm sorry, 003.
I was going to say that's the declaration value. Yes, that's correct. And that's my signature notarized by my assistant, Roxanne Dove Doyle, and then further next page, directed by Amelia to do the declaration of value and take care of the recording.
And if we can go to 002, please, Lindsay. It appears to have the same subject to language in bold. And then the same language beneath that. It appears to mirror the language we just saw in the prior grant and conveyance deed.
Correct.
You can take it down, Lindsay. Mr. Whittemore, or Lindsay, would I have, can you please provide state's proposed exhibit 3346? And tell me, Mr. Whittemore, if you can identify that document, and it's fairly lengthy, so if you'd like to peruse your way through it.
I can tell you what it is. It's a document that the logo and the banding on the left-hand side, what we did was create a color scheme in a project that Coyote Springs is basically a CNS above the Coyote Springs and sort of a waterway going through a desert. So it's sort of a demarcation of what we wanted the visual representation of the development to look like, color schemes, that sort of thing. And what it is a very significant prepared document that we would provide to those that would be interested in what was happening with respect to the project.
Is it a marketing tool?
Yes, sir.
And marketing for potential commercial and residential builders, or
A little bit of everybody. I mean, the project itself was so significant, there was interest from multiple people. And so we wanted something that was done very, very professionally.
do you recall who prepared it? Is this R&R?
This was,
R&R?
yes, this document would have been, they would have participated in the development and presentation of the project itself, but the bulk of what's in it would have been done by our team. I would, and again, subject to the exception, Your Honor, assuming it's a complete, document.
Well, it's certainly long enough. So I believe that it's complete. And do you recall, Mr. Whittemore, if this was actually disseminated to potential or interested parties or purchasers?
I recall having the document with me on multiple occasions, and I would have shown it to people. I don't think it was ever, I don't recall that there was a different version, and therefore if I could just go through scan a couple pages just to see the completeness.
Sure, would you, Lindsay, just scan through it a little bit for him?
Yeah, these are all things that I recognize. The town away, a world apart, the marketing stuff, it's clearly something that I recognize.
Lindsay, can you go to 019, please? Let's just show you some of the maps that are actually used and annexed to the overview. And this appears to, and tell me if you can identify it as essentially a overview of the map and the legend that designates the different areas for potential development.
That's what it's designed to do. It shows a community district plan and fit different villages. We've talked about this. The outline, Your Honor, is the outline of Coyote Springs, including Clark and Lincoln County. It shows a banded area, which is the area that was part of in the multi-species habitat conservation plan, and then shows the various villages along the wash. Shows the interior road of old Highway 93, and it's part of the marketing.
And the top portion is Lincoln County, and item number 9 seems to correspond to traditional residential villages 2. You can see on the right hand, there you go.
Yes.
How many golf courses did you intend?
We talked about there potentially being anywhere between 5 and 10 golf courses. There were some idea that it could be more, but I always had the thought that there would be 5 to 10.
And if you look at, go back to the map for a second, Lindsay, if that item designated as 3 is both across the Lincoln County and Clark County, and that appears to be in the legend traditional residential villages 1.
Yes, the number 3 on the left-hand side, Your Honor, immediately to the east of US Highway 93, you'll see a legend that's number 3, which shows that the residential village crosses the Clark County line into the Lincoln County line.
And the green shaded area is Coyote Springs Nature Preserve. Can you explain that a little bit?
What I just indicated, that what we were trying to do was to get the buffer to create a nature preserve that would preclude development and in effect create open space for the community. I wanted Your Honor, the parks, I don't know if it shows this on number 5, through the center of the development, Your Honor. What I wanted was one of the largest parks in the desert Southwest to be to cut through the property. And so you see it starts at the bottom of 168 and heads from 168 northwest through the property, and created a huge green space, open space. Yes. And so what we wanted to do, Your Honor, was to create this extraordinary walking park throughout the course of the development.
Thank you, Mr. Whittemore. If we can go, Lindsay, back to 010, please. Yeah, I'd offer proposed exhibit 3346, please.
No objection, Your Honor.
And this appears to be a general overview of the Coyote Springs proposed master plan communities. Does that comport with your understanding of the document?
Yes, what we did was choose a number in the previous pages, a number of pictures which shows what our vision was of the community. And then this is a description that is based upon, what my vision was with the team, and to basically describe the water that we had, what the formations of the valley were, what the carbonate aquifer was, those sorts of things, Your Honor.
In the paragraph that begins, CSI has already entitled the property for almost 50,000 residential units. Would that include both Lincoln County and Clark County, or just Lincoln County at that point? I'm sorry, just Clark County at that point.
I don't know that we limited it just to Clark County. You can see the reference to the number of golf courses at 6. The Lincoln County lands would be 80. So there's the 130,000. And I think we ended up with more than that based upon the development, the approved development documents in both counties.
Go back to 004, please, Lindsay. And we'll just end with just a quick discussion of the Coyote Spring quick facts.
Sure.
Just highlight the entirety of that column. There we go.
Okay.
It's again just describing it, where it's located, how many minutes of a drive it is, and then it's the 42,000 acres, and then it has a delineation or allocation of that portion in Clark County and Lincoln County, and then it talks about the current entitlement and approvals. It looks like 130 residential units over 5,000 acres, and then it says 15 golf courses. That's generally what was envisioned, at least at the time this was.
Yes, at the time that this was done, we were contemplating an ability to build more courses. I always thought that the demand cycle of this would be more in the order of 5 to 10 golf courses, because we wanted to be able to use the effluent water that was being created as a result of the scope of the development to use the water on our property and put it back in place. I think that the 5,000 acre reference was to the remainder of the portion that would be used for commercial development.
Thank you. Linda, you can take that down. Now I want to talk a little bit about when Albert Sino Jr. enters the picture. And if you could, Lindsay, bring up states 3396. Now by 2004, as I recall your testimony, is when Tom Sino became involved. At least that's the general time frame that I recall.
Correct. After
And-
David Loeb passed away.
And he purchased, that is Albert Sino Jr. purchased a portion of Tom Sino's interest in and around 2007. Is that accurate?
It's about the same time, correct?
And then Albert Sino Jr. acquired a portion of your interest in a number of entities on the June 21st, 2007 date, at least the date of the agreement.
That's correct.
Can you describe for the court the reason why or the purpose, to your knowledge, that Mr. Sino Jr. acquired an ownership interest?
I was asked by Mr. Sino's, Mr. Albert Sino's brother, Tom Sino, and Mr. Albert and Tom Sino's partner, Bill Paganetti, to offer for Albert the ability to come into Coyote Springs. I was advised that there was a sense that it would resolve a lingering dispute between Tom and Albert, that it would help Bill Paganetti and the Peppermill ownership resolve any potential issues there. So it was something that I was asked to consider, and we ultimately did.
Were you attempting to raise capital for the development of CSI?
I was convinced that Albert had Mr. Albert Sino had significant resources, and that he had a specialized skill in the development of property. Clearly, Mr. Albert Sino had a better life experience than I did in terms of being able to look at documents associated with infrastructure development, a real good skill set in terms of what he had done in California. And both he and Tom were considered strong developers in their own right, and thought that by adding Mr. Albert Sino to the team, that it would accrue to the benefit of the entire project.
But not for the production of the development of production homes.
Not at that time. I knew that Mr. Albert Sino would be someone who could test and give us good information as to what part he was proposing to do. He had a skill set that was much different than mine. His was broader with respect to the construction industry, that's for sure.
Did you negotiate this transaction personally?
Yes, we talked about it with his advisors, Kevin McCauley, and but at the time we came up with what we thought was a fair price based upon what Tom wanted, and it was consistent with something that I thought would be effective for the team.
Did you explain to Mr. Albert Sino Jr. what the business plan of CSI was?
He was aware of it before this took place. This was not something that he was unaware of, because he and Tom were partners on literally everything. And so he knew what Tom had, and Tom knew what Albert had. So he knew about Coyote Springs. He had, in fact, he had declined to participate at the beginning of the transaction. Yeah, I didn't go to Tom Sino exclusively, but I think that Mr. Albert Sino was interested at the point that all of this took place, because we were on the road to what I thought was a very effective and good program.
Did you recall Albert Sino Jr. doing any due diligence in connection with the acquisition of these interests?
It
Judge's
is-
Foundation.
He's assessing what he knows, right?
That's what my question was.
Yes, I was aware that Mr. Sino did. Your Honor, would it be okay if I just call Mr. Sino, and then if it's Tom, I'll say Tom? So this Mr. Sino's people had complete access to all of our documentation, and I spent significant time with Kevin McCauley and Tom's person, Larry Gunderson, in describing all of the various assets that he was purchasing into.
And we'll talk about those assets, but as it relates to CSI, did you recall having discussions or providing information to Mr. Sino with respect to, for instance, the party agreement
Yes,
and whatever various amendments may have taken place?
certainly.
And would that have included the takedown schedule that we looked at?
Most assuredly.
And did you share information with Mr. Sino with regard to the water rights and permits that were held by CSI?
We talked generally about the status of the entitlements, our assets with respect to Coyote Springs, generally with respect to all the other assets which were part of the purchase. Obviously, not obviously, Your Honor. When you do a deal of this nature, you provide what any documentation that's requested. You make sure that your records are an open book so that people can come in and look at them. There was nothing that was withheld.
Do you remember providing information with respect to the SNWA groundwater pipeline project?
We talked about the pipeline project. He was aware of what the proposed plan was. He was aware of what we were doing with respect to the Tuffy. Well, we talked about the Tuffy Ranch purchase, so he was aware of it.
By that time, he knows, at least CSI has entered into the capacity agreement and guarantee. We looked at those documents a bit ago.
Yes, this is a area where I have to be quite specific, Your Honor. As I recall, I did not have a specific discussion with Albert personally between myself and Mr. Sino about that specific set of documents. One of the things that I can't say as I sit here today is that I went through chapter and verse A to Z, every single document that they had access to. You don't generally do that principle to principle. You make sure that things are available. You rely on the other party's ability to look at the documents, raise questions, answers. But as I sit here today, I can't tell you with specificity that I ever had a conversation with Albert about specifically a capacity agreement or a particular deed or an application that had a specific number. That generally wasn't how principals conduct themselves with respect to transactions. You get people that do due diligence and you go through box after box and you say, what does this look like? And then they make a decision, yes or no.
Do you recall having any conversations with Albert Sino Jr. with respect to the need and necessity of water?
Oh, of course.
And would that conversation have included the idea that there was an agreement to tap into, if you will, the SNWA pipeline project itself?
The conversation with Mr. Sino would have covered things like, this is what we're attempting to do with respect to the total number of water rights. This is what we have in place. This is what we're trying to do. Describe the difference between Nevada water law versus California. That the project needed additional water, that there was no certain amount, because with certainty, we're at the point of this transaction where there is no great certainty. You're in the middle of trying to get more and more water.
At this point in 2007, I think construction had started on the golf course. Is that with your recollection?
Yes, I think that's correct. We can pull up the Nicholas documents and you can get the specific date, but
I don't think there's a quarrel about that.
okay.
I don't think.
All right.
So let's just look at the purchase and sale agreement, and it appears that Albert Sino is acquiring more than an interest in CSI. Is that accurate?
Yes, sir. He was buying into all of the various Whittemore entities.
And there was a reason why he was buying into more than CSI, to your knowledge?
Yes, because he wanted to ensure that he had an interest in all of the entities that I had an ownership interest in, because that was the same deal that I had with Tom. Because when Tom came in, as we previously discussed, I gave him a 50% interest in 100% of the Whittemore entities for his contribution, and Tom wanted to sell his a portion of his interest, 16% plus or minus the percentage points, and I was doing the same so that we'd become 1/3 owners in the combined entities.
But the Whittemore entities owned more than just CSI, didn't they?
Correct.
We go to the 003, it has a purchase price of $44,100,000.
It's correct.
And that's for whatever the percentage interests were collectively in the various Whittemore entities.
At that time, all of these are combined entities. So now he's purchasing that interest from my interest in the combined entities.
If we, Linda, can you go to 006, please? This is Exhibit A to the purchase and sale agreement, and it appears to be a listing of all of the various Whittemore entities. Is that accurate?
Yes, that's what we were attempting to do.
Do you have a Dr. Pepper 7-Up bottling? I'm just working through some of these.
Yes, Your Honor, I had an interest in Dr. Pepper 7-Up Bottling Company of the West, which owned the only bottling plant in Reno, Nevada for 7-Up, and Dr. Pepper was actually a bottling company. So I had an interest in that, and that was included.
Then he buys an interest in the Geyser Ranch LLC. We talked, what is Geyser Ranch?
Geyser Ranch is the adjacent property to Tuffy Ranch. It was included in the Tuffy Ranch purchase, but Atlanta Farms, Geyser Ranch is the specific name.
And then the Tuffy Ranch properties, that's the same thing we just talked about?
That's correct.
What are all the Farmington entities?
Oil and gas entities in West Virginia, Your Honor.
And then Red Hawk Land Company, what's that?
That's the entity that is associated with the Wingfield Springs community, Red Hawk Land Company, Foothills. You'll see that.
And was that one part of the smaller master plan community up north?
Huge for up north, but small compared to down here, I guess.
Is that located in Sparks?
It is.
How many homes are that in that?
Over 4,000 with respect to both Red Hawk, the Wingfield Springs community sign, Red Hawk being the name of the golf course and the name of our entity, and then the Foothills at Wingfield Springs, which is adjacent, but about 4,000 homes, Your Honor.
And after that, assuming it closed and he paid you the purchase price, did he assume a management role at that time?
He was, he was involved, very much in terms of, watching what was happening. I think that, Mr. Sino is someone who watches investments closely.
But was he a manager to your knowledge?
Oh, yeah, excuse me. Yes, he was, he became a manager of those entities pursuant to the agreements, and he would have been considered to be an active investor for purposes of the IRS. He would not be, that would not be a passive investment. So according to the rules, Your Honor, he would be active.
After you purchased the Tuffy Ranch property and water, do you recall filing an application to move that water, certificated water from Lake Valley down to the Lincoln County portion of the National Plan community?
Yes, as we previously described in earlier testimony, Your Honor, we went through a hearing process to allow us to move on an interbasin basis. Some of the water from the Tuffy Ranch, Geyser Ranch areas down to, which is Lake Valley, to Coyote Springs.
We've referred to that in this proceedings as the 5918 ruling or order. That's
Yes.
before with your understanding?
Yes, sir.
Okay. And there was a hearing that that you attended and testified at with regard to the request to change the essentially the place of use. Do you recall that?
Yes, sir.
Lindsay, can I have 3933, please? This is a copy of the transcript from that hearing. One second. And Lindsay, if you can go to 0178, it's a lengthy transcript, but there's a portion of the transcript I want to have you addressed.
Yes, sir.
And do you recall, generally speaking, what you had to show or Tuffy Ranch had to show or demonstrate to the state engineer with regard to both the ability to cause the worker improvements to be done to move that water and the need and necessity to move it?
Yes, there's statutory requirements on an interbasin transfer that need to show the availability of the water, that you have the capacity, means, and methods to move the water, that there's a need, which from our perspective was pretty straightforward with respect to the planned development at Coyote Springs. So I thought we met the statutory criteria and made a decision to pursue those applications to move the water because I thought we complied. I thought we had a great case.
And one of the things I think you had to do was to demonstrate the necessity. In other words, why do you need to have that water come down?
Yes, sir.
And do you recall what you told the state engineer with respect to the necessity of bringing that water down for development?
I said that we needed additional water to ensure the availability of sufficient water to proceed and deliver water on a permanent basis to potential residents. I said I think I recall, and I think I said in the deposition, I didn't want the showers to run dry or people to have to strap water on their backs or bring it in by trucks and that sort of thing, Your Honor.
Lindsay, can you turn to, actually, I don't have the page number. I believe it's page 178. Let me see if I can. Pardon me?
3933.
Less helpful. Okay. Do you want to use that one? That one. We'll circle back, Mr. Whitmore.
Okay.
You recall in the examination at the time that there was a question by the state engineer as to whether or not, what would happen if SMWA didn't build the pipeline?
We had a short discussion on that because I think that what I said was that we would have the capacity to potentially build our own pipeline.
And how, did you demonstrate that you had the capacity to do that?
I think I testified that we had probably the ability to acquire capital necessary to pay for the pipeline and to charge the ultimate users with appropriate levels of hookup fees to pay for the price associated with the construction of the pipeline. I didn't have an order of magnitude specifically down to the penny, Your Honor, of what the price per mile was. But, you know, we had a pretty good idea that it was an expensive proposition, but that over the number of homes that would benefit from the pipeline, that it could be achieved.
Yeah, may I approach the screen for just a moment?
Yes,
Can't see it.
Your Honor, can I ask that it be expanded?
yes.
Thank you. Thanks, Your Honor. Okay.
Did you approximate the cost of that?
Well, we said, I think that what I said was that assuming that Jeremy Aguero's testimony or delivery of documentation to me, that it might be about $10,000 per unit, I think I recall. So there it says 6 to 10 per unit to bring the pipeline, sufficient to bring water to our project in today's dollars. Per unit.
Per unit.
Now, again, in today's dollars, that was back then, today's dollar might be 20,000. I can't give you a number, Your Honor, based until, you know, you had a price per mile.
Lindsay, can you scroll up to page 168, please? I think you have it. Court's indulgence. We want it. She is. She's on the. I'd move to admit state's proposed 3933.
No objection, Your Honor.
Admitted.
Lindsay, can I have state's proposed 3411? Recall following the hearing, the state engineer permitted closing statements,
Yes, I do.
and this is the closing statement filed by a counsel for CSI at the time.
That's
Tucker
correct.
Ranch.
That's correct. Louis Morocco.
And the introduction states that the applicant cannot understate the importance of these applications. The success of the Coyote Springs project depends in large part upon a favorable outcome of the instant application. The future economic development in Lincoln County in turn hinges on the successful development of the Coyote Springs project. What did you understand that to mean, sir, at the time it was filed?
That the ability to move a portion of the water from Tuffy Ranches was essential for us to have a successful development at Coyote Springs, especially the Lincoln County portion.
And if you go to 005, Lindsay, please. It says in the middle of the first paragraph, finally, Mr. Whittemore and Mr. Aguero testified that even if S&W's pipeline is not constructed, the development could viably support the cost for CSI to build its own pipeline. And that's consistent with your testimony a moment ago.
Yes, sir.
Lindsay, may I have States Exhibit 3426? And this is the ruling that follows from that hearing, sir?
That's correct. Ruling 5918.
If you go to, Lindsay, go to 024, please. And the last paragraph, beneficial use and reasonable diligence. This testimony was provided that the Coyote Spring development is progressing and the applicant, through its association with Coyote Springs Investment, has continued to pursue development. And so it appears, at least through the balance of that paragraph, you're describing the work that is taking place on the Clark County portion.
That's correct.
Also, development plans with respect to Lincoln County have not changed, and then ultimately in build out, they would like to develop up to 100,000 homes in Lincoln County, depending on the availability of natural resources. And that was still the intent at that time.
That's correct.
You can bring it down with. Lindsay, can I have state's proposed 3417, please? And tell me, Mr. Whittemore, if you can identify that document.
Yes.
And tell the court what it is, please. And you can have Lindsay scroll through it if you like.
Sure. I'd like to just make sure that it's a version that. Okay. Okay. I understand what it is.
Okay. Tell the court generally what this is.
Your Honor, this is again a marketing piece which shows the status of development and the water rights holdings as of September, the 2008 timeframe. If Lindsay can move to the visual, then I think it's the next page. It shows what the next page, please. Right there. It shows what the proposed development might look like with respect to phase one on the southwestern edge. On the left-hand side of the picture, Your Honor, that's Highway 93 going north. And at the bottom of the picture, it's Highway 168 moving from west to generally east, southeast. You see the wash in the middle, the shaded area above phase one. That's the area that I previously described to Your Honor as the open space park area, a very large, very, very large park cutting through the center of the project. You see some lakes that are part of the storage for the golf course. You see the first golf course layout designed by Jack Nicklaus on the left-hand side, with some of the holes on the right-hand side as the entry monumentation coming in of the next course. That would have been a Jack Nicklaus Peak Dye course, Your Honor. So again, it's a summary of what the development looks like at a particular point in time for those that are interested in seeing what our progress is.
Thank you. If we can turn to, and again, this is summer of 2008, at least that appears from the base page of the document.
That's correct, somewhere in there.
And for what purpose is this being prepared?
Again, it's a document which we're working with Pardee on representing what the status of the development is for people that are interested in seeing it. There's multiple at this time, council, there are multiple parties throughout Southern Nevada that want to know what the status of the project is.
We can go to 003, please. And this is the introduction to the executive summary. For the first bullet point, please. Talks about the total number of miles in the 42,000 acres, and that's 65 square miles.
Yes, sir. About, I always used to say it was 13 by 5 miles wide, 13 miles long. It's about 65 total square miles. And again, the number 42,008 is correct. We then describe what the size and scope is as compared to Summerlin, because people know that. We talk about the number of units we have approved. This is probably one of the first documents that we describe that we have an exclusive agreement with the PGA of America to become what I previously talked about in earlier testimony, the West PGA Village. That designation was extremely important. Huge get, as they say in the business, to acquire the designation from the PGA of America.
Is that, by the way, is that just limited to the one course, or would it?
No, this was going to be a PGA Village, which would include multiple courses coming out of a central PGA Village core with great big clock towers, the stuff that you see on TV all the time.
Both on Lincoln County and Clark County?
Well, again, the phasing was, as you know, council, was always from Clark County going north. We weren't going to hit Lincoln County, within a year. It was going to be, it was going to take time.
Right.
But yeah, I mean, I don't think we can mischaracterize. I don't think we can characterize this project as one phase. It's many phases.
And the next bullet point is the developer Wingfield Nevada Group and its principals, deeply experienced. And then there's a sort of a summary of both you and both of the CNOs. You see that?
Yes, I do.
This also reference to various other interests, including oil and gas, bottling, and casinos. Is that just the Whittemore entities as a whole?
Those are the Whittemore entities and the CNO entities. At the time, I did not, and I do not have an interest in casino, although there might have been a licensing matter with respect to an option, but we were not owners of a casino like the CNOs were.
Okay. Can I go to 006, please? This is the key development milestones. And the first one indicates the total 42,000 acres acquired from Aerojet. And there's a reference to the Party Homes sale with an option of 11,050 additional acres. And then it goes on to talk about the acquisition and option. Again, this is just generally providing a description of the milestones that have been achieved as of 2008.
That's fair. I think that this says summer of 2008. I think the last bullet point is October 2008, which is fall of 2008. It already references that the Lincoln County Multi-Species Habitat Conservation Plan has been executed. So by that bullet point, it would tell me that the face page of saying summer is probably, inaccurate. It might have been the fall of 2008.
Can I go to 0015, please? This references a summary as of whatever the date of whether it be the summer or fall of 2008.
Mm-hmm.
It says Coyote Springs resides in Coyote Springs Valley, and Coyote Springs Valley Basin sits above one of the largest water aquifers in Southern Nevada. Now, this is before, it's after 1169, but before the pump test have actually commenced, correct?
Correct.
Company believes that it can service the entire community with water from the Coyote Springs Valley Basin upon obtaining the appropriate water rights. Again, that was still your belief at the time.
Correct, although we wanted insurance policies, I've made that clear that I wanted to buy more and more water.
Indicates the next bullet point that you need 70,000, at least you estimated 70,000 acre feet annually.
True. That was assuming a utilization of approximately half an acre foot times the number of units, et cetera, et cetera, et cetera.
And the last bullet point indicates that the company is in the process of securing additional water rights and references the 108,585 acre feet. That's the pending application from 1169.
That's correct.
The next page is 0016. There's a reference, additional references to the water rights. Talks about the Tuffy Ranch property, water of 43,000 acre feet. Is that the total number of acre feet that was acquired?
It was the number which we anticipated Tuffy would ultimately be able to acquire, correct?
Okay. And then under contract is the 2,000 to 5,000. That's the Cane Springs water that we talked about before.
Correct.
And then owns 763 acre feet in Meadow Valley, California, and Moapa. Are those all within the lower White River flow system, those basins?
Yes.
And then pending applications seeking new appropriations within Lake Valley, that says 74,929. Can you tell the court what that relates to?
We did the same thing in the Lake Valley Basin that we did in the Coyote Springs Valley, which was to try to capture 100% of the available water, knowing that the number probably, that was a best guess based upon people telling me what to file.
And then last bullet, or second to last bullet point, references the SNWA capacity agreement, I should say, to bring that water down through the pipeline.
That's correct.
You can bring it down, Lindy. Is it done? If it hasn't, I'd proffer state's proposed exhibit 3417.
No objection, Your Honor.
Thank you, Council.
Admitted.
Lindsay, can we try again, go back to 3933? I think I got it sorted out. Think. Can you turn to 3393186? I can't read.
Okay.
Be a little closer to it. Put it down a little bit, Lindsay.
Okay.
Jeff, so last sentence on 186 that starts with as you know.
There it goes. In the bottom of page 178, there you go. It says, as you know,
Okay.
1169 suggests that we may have to cut back on pumping in Coyote Springs if there's an impact in the Wapadace or to the springs, and therefore we might replace a pumping cycle that suggests that we may trade with the Southern Nevada Water Authority for resources that they have. This appears to be recognition, sir, that 1169 may in fact restrict or limit the amount of water that is already permitted under 4677. Do you agree with that?
Objection. Document speaks for itself. Calls for no conclusion.
It's his testimony in the transcript, John.
This is interesting.
My testimony there is the same as I would make it right now. It's that Order 1169 creates a level of when you read 1169, you have to be aware that one of the outgrowths of the pump test, as I previously testified, is that we could show that there's more water or less water, and you have to adjust behavior depending upon what the pump test shows. My obligation as the master developer is to de-risk the fact that water wouldn't be available in Coyote Springs, and therefore this is all about us trying to get additional resource down to Coyote Springs.
Thank you, Mr. Winterhawk. I just have a couple more questions. If you bring that down, Lindsay, and bring back up 3288. That's the letter from Mr. Saban, is it not, sir?
That's the email from Carl to Marvin and Lynn at CSI, at Resource Concepts.
In the paragraph that begins the state engineer's findings. It says based on insufficient data, is order for a 5-year study, additional monitoring locations and pumping of the permitted rights for 2 years, and an update of the SNW model based on new data collecting. All this work must be completed before the state engineer makes any further action regarding pending applications. And when did you go to the next paragraph, please? I call your attention that if the study does conclude the basis over appropriate, it will not support even the existing permitted rights. The state engineer clearly has authority under Nevada water law to restrict production from the resource to protect the prior existing rights. Isn't that consistent with what you just read as your testimony in 1169 hearings?
Yes, sir.
You can take it down. Mr. Whittemore, did you ever obtain during the time period in which you owned or controlled CSI, obtain financing from conventional lenders?
Yes, as I previously indicated, we used credit lines to fund ongoing operations, and then paid those obligations down through revenue that came into the various companies, whether it was operations from the golf course or sales of land, et cetera.
Do you recall arranging for a credit facility from Wells Fargo?
It was part of one of the recommendations that the CNOs had made to me to have CSI arrange for a credit line, a loan.
And did CSI pledge its assets in connection with that credit facility?
Yes,
Did it include both real and personal property?
it would have included, based upon my recollection, I think we pledged probably an interest in everything because that's what banks do.
Would that include, do you recall actually pledging the permitted water rights?
It would have.
To the best of your recollection, did you ever guarantee to any financial institution, including Wells Fargo, that the collateral that was the water permits was a guarantee that that water would be available in the future?
No,
How can you be so sure?
I didn't sign a guarantee to that effect because I could not have done that. I would not have done it. I knew that I know Nevada water law, and that wouldn't be what you could do.
You wouldn't do.
No, I wouldn't do it. I don't think anybody would.
What do I tell I have?
Thank you.
Thank you.
All right, there's be direct.
Thank you, Your Honor. Let me get good afternoon.
Good afternoon, Council.
Whittemore. Let me just follow up on a couple points that council had made before. Kind of go reverse chronological, on just a couple of points there. Hunter, can we pull up 3933? I think that's that Tuffy Ranch change application transcript. I think it was 0186. I think it's got on the bottom, it was that bottom, I think it was lines 22 through 25 that we just read, and my site's about as good as Mr. Sylvester's site, so can I move up here, Your Honor?
Yes.
Okay. So you were just read with counsel, Mr. Whittemore, that line, you saw that line 23 through 25. As you know, Order 1169 suggests that we may have to cut back on pumping in Coyote Springs if there's an impact on the Wappadace Orchard Springs. Remember, you just were asked about that.
Yes, sir.
That's never happened, right? There's never been a determination by the state engineer that in fact, cut pumping in Coyote Springs has had an adverse impact on the Wappadace or on the springs.
Section Big Foundation is biggest of time.
You said ever, right?
Ever. Yeah.
Overruled.
I don't know of any order that suggests that, I'm not aware of any.
Right, so you were just talking about, it could happen in the future, but it did, to your knowledge, it never did happen.
Certainly didn't happen when I was there, and I don't know post 2011. Again, as I've testified to, I was not around when the pump test was finished, and I don't know exactly, what the engineer has said or didn't say in documents with CSI. So.
Right. After you've left, you don't know what's happened, but certainly during the time that you were there, the 12 years or so when you were there, state engineer never came out, to your knowledge, and said, Coyote Springs pumping is having an adverse impact on the Wappadace or the Muddy Springs Valley area.
Did not happen.
I'm going to go back to a couple of those brochures that you were shown. I think I'm going to do that based on the order that I've got in here in my outline with you, if that's going to be all right. You'd mentioned a couple times Jeremy Aguero.
Yes, sir.
And he was somebody who you had retained on behalf of Coyote Springs. Is that correct?
Yes, sir.
Was he part of that, when you and I first talked about this a month ago, I think now, you talked about, maybe it was my characterization, is sort of this top shelf, this top flight team that you had around you, and that we saw so many of these impressive features within Coyote Springs and the accomplishments that you've all accomplished together. Did you consider Jeremy Aguero to be part of that team?
Yes, sir.
What's your opinion of Jeremy Aguero at the time, just based on your experience, in terms of just Jeremy Aguero? Can you kind of explain to the court who Jeremy Aguero is or was the time that you worked with Jeremy, what he did for you, and what your impressions were based on your experience?
Well, Jeremy is, he's probably recognized as one of the top folks in the region and state, probably on a regional basis now. I haven't followed Jeremy's career that closely, but Your Honor, he was recognized as someone who could really put together a very clean and clear financing picture of what the effects would be. If you did A and it cost B, then the result would be C type of analysis, and really gave us a good idea as to what expected results would accrue to particular actions. So I would consider Jeremy to be really a top guy. He gave us, I think, good advice with respect to how to approach decision makers. He was well respected down here. So when our team went in, and it was myself, Greg Borgell, Jeremy Aguero, Billy Vasiliadis, all of our folks, I stand by it, and I've said it. I thought we put together a really, really good team.
And in your experience, is Jeremy Aguero professionally competent,
Objection relevance? Overruled.
Yes,
professionally accomplished,
yes,
trustworthy,
yes,
based on your experience?
yes. Yeah, it's
Somebody who you have certainly trusted with an awful lot of money at stake,
Objection leading?
correct?
I'll allow it. Said I'll allow it.
Okay, I'm sorry, I didn't hear. Go ahead.
Yes, Jeremy was, Jeremy was and is in my mind someone that whose judgment you can trust.
Mr. Whitmore, just want to review a couple of points with you here about some of the testimony you'd given, like I said, about a month ago when you and I had a chance to have a Q&A in this court. And one of the things that you had testified was that one of the key reasons you purchased the Nevada water power rights that we've been talking so often about, permit 4677, was because those rights were senior rights within the basin. You remember correct? You remember that?
Correct.
Talked a lot about that. And the reason the senior rights were important was that you felt it was important that CSI be first in time because of just the nature of water law in the state of Nevada.
Objection leading?
Correct?
It's a premise for question. Go ahead.
That's correct.
Yeah, just, can I address the reading, Your Honor? Mr. Whittemore is a wonderful witness. Appreciate him. He's here by subpoena. So I brought him here by subpoena. So the fact that I brought him here by subpoena, but doesn't make him, Your Honor, my witness. So I would ask that I be allowed to, when appropriate, lead the witness.
I don't mind foundational leading, Your Honor, but to the extent that he is on direct examination of the witness that they've called, you can't examine him by leading questions.
All opinions.
He's sorry.
I'm sorry.
He's the founder of CSI and the member and manager for 10 or 11 years following that. So I don't think he hasn't shown any adversity with respect to an inhibition of denying the answer or resisting.
I agree.
I'm sorry.
I don't think you can ask leading questions.
Nothing directed to you, Mr. Whitmore. Bunch of lawyer stuff, right? Okay.
I'm very well aware of it.
Okay. Okay. And Mr. Whitmore, those 4677 water rights would have been first in time and right in the area that you were concerned about, which was the Coyote Springs Basin, correct?
Still leading, Your Honor.
Yes, but in the interest of time, I'll allow it. I don't see.
Okay, yes, I have a standing objection, Your Honor.
Yes.
I'm going to repeat the question.
I don't need it. Yes, it was my desire to, as I previously testified, that what we wanted to do was to create a base right that was senior and better than all others.
Yep. And nothing in your testimony in this trial was meant to contradict that prior testimony, was it?
Objection overbrought.
Sustained.
Do you still stand by that testimony today?
Same objection, Your Honor.
Which testimony?
That those 4677 water rights would have been first in right in time in the area that he was concerned about, which was the Coyote Springs Basin.
Limiting it to that, I'll allow it.
Do you still stand by that?
I do.
And in fact, Mr. Whittemore, securing the senior water rights within Coyote Springs Basin was central to your acquisition strategy, correct?
Significant part of it, yes.
And when you purchased those senior rights, they were first in the basin, not first in the lower White River flow system, correct?
First in the basin as I understood it at the time that I purchased the water rights.
That would have been the Coyote Springs Basin, correct?
Under the designate, as I understood it, it would be the first in time, first in line, first in right with respect to the Coyote Springs hydrographic basin, correct?
And you weren't concerned about being first in the state or first in the world. You wanted to be first in the Coyote Springs Basin, correct?
Yes.
In fact, you would not have purchased the Nevada Power water rights if you didn't think that they had added substantial value to the project.
It's a true statement.
In fact, you wouldn't buy an asset such as a water permit if it couldn't be used in the project, correct?
I wouldn't purchase an asset that was designed for the project if it couldn't be used on the project. Yeah, I think that's fair.
Okay. And that would apply to permit 46777, right?
I think so.
We talked about you testifying before the state engineer concerning the hearing on order 1169. And I'd just like to pull up the transcript on that. Okay, that's exhibit 128, Hunter. And I'd offer this exhibit, Your Honor, exhibit 128.
I think it's in.
Oh, is it in?
If not, I'll skip it.
Okay, thank you.
It's. You said 128?
Yes, 128. Yep.
It has not been yet.
So 128 has now been admitted.
Judge.
Admitted, yes.
Thank you. Mr. Whittemore, you have made it very clear, at least in this hearing, that Coyote Springs property has minimal economic value without usable water rights, correct?
I don't know if I ever used the word minimal.
Okay.
If I did, I don't know in what context, because I think that the resource of 42,000 acres of land would have potential value for any number of uses. The mining operations that we talked about, the gravel and sand operations, if it had no water, it would be very difficult to make things work that had zero water. If it had some water, it goes up. But again, one of the things that we tried to avoid was to create this hodgepodge development, Your Honor, of 40-acre parcels with people drilling their own wells and creating a different sort of Pahrump and having no, and I don't mean to denigrate Pahrump, but no there with no golf course, no significance. Yeah, it would have, for the price that we paid. Does it have economic value? Yes. I'd have to do an analysis right now. If you said, Harvey, what would you pay per acre right now for Coyote Springs? But it would take me some time to do that.
All right, let me just pull up my exhibits here.
Sure.
Give me a second. Or if we can go to we can go to page 010 of the transcript. That'll pull up there for you in just a minute. This is unfortunately the form that we have of this transcript. So it's kind of small and hard to see sometimes, but I'm going to try to blow it up for you there.
Okay.
And what I'd like to have you do is just take a look at page 40. It's page 48, lower left-hand corner there. Yeah, if you could down there, just and you see where the question begins. Why in that second half, Hunter? Don't need that. Don't need that right now. Just that lower left-hand side.
Okay.
That's it. Just blow that up so Mr. Whitmore can see that.
Right.
Yeah. Question. Why? Yes, I do know. Basically, my partners and I were not going to close with Aerojet until we knew that the original applications that were filed by Aerojet were issued, because quite frankly, the land, while it is a large tract of land, really has minimal economic value without water resources associated with that land.
Okay.
Accurate, recitation of your testimony at the time?
Yes.
Okay. Let me just ask you another question. At the time of the acquisition of the property, the Aerojet property, and the water rights we've been discussing, you at that time, you just didn't have this concept in your mind of jointly or conjunctively managed basins at the time of the acquisition, right?
Objection for the question?
Sustained, you need to.
Sure. Taking you to the time of the acquisition of the Aerojet property.
Yes, sir.
Time of that, at that time, you didn't have in your mind this term or this idea or this concept of jointly or conjunctively managed basins, correct?
Objection.
Singular.
All right. When you purchased the Aerojet property,
Yes.
in your mind, in your considerations, did you think about conjunctively managed basins around the property you were buying?
Objection form of the question vague as to conjunctively managed basins.
Overruled.
Counsel, at the time that this transaction took place, you and I previously talked about the fact that we, in my practice, I had never used the terms conjunctively managed. We had previously talked about in my testimony that what I knew to be the case was that the state water engineer could be concerned about administratively handling adjacent basins as a result of the impact that someone could have on a neighbor. And I think we talked about that in my earlier testimony, that we always knew that you couldn't pump a well if it was impacting a rancher next door, a neighbor. In that sense, I don't think people talked about conjunctive management, at least in my frame of reference at this time. Okay.
Let me, I know it's been a little while. Can you remember your deposition was taken in the case?
Yes, sir.
Over, what was it, 3 days?
Yes, sir.
May I publish his deposition on it?
Sure.
There are 3 volumes. I need volume 2 of Mr. Williams.
That's what I was gonna mention a minute ago. I don't have one. Sorry.
You don't have any of the transcripts, I think? Do you have? Okay, thank you. Volume 2, please, yes. Thank you so much.
Are we publishing the entirety of the deposition or just volume 2?
We might do the entirety of the deposition now. Volumes 1 through 3.
Do you need the hard copy or are you gonna use electronic?
You know, I was gonna show the witness the hard copy, if that's all right. Thank you. Yeah, first the witness, Yar. Thank you. There you go. Mr. Whittemore, I know it's been a little bit of a time since you've had your deposition, so I'm just giving you this so we can take a look at your deposition together, okay? I'm on volume 2, page 28, line 23. Just let me know when you're there.
Okay.
Question, and you knew and understood that at least at the time of the acquisition of property and the water rights in this case, and I made an objection, Your Honor, but this was Mr. Sylvester's question, so I'm going to withdraw that objection. So let me start again.
Okay.
Question, as you knew and understood that at least at the time of the acquisition of the property and the water rights in this case, witness, that's you, Mr. Whittemore, I did not think specifically about that concept when I was purchasing the property. The words conjunctive management did not come into my head. Recall that testimony now?
I thought that's what I just said.
Good.
Okay. If I didn't, I agree.
If you didn't, that's what you intended to convey.
Yes.
Fair. Okay, thank you.
I would just object as improper impeachment, Your Honor, since he just said the same thing.
I can respond to that, Your Honor,
No.
but you overruled it. Thank you. And Mr. Whittemore, multi-basin reordering of priorities within those basins, those priority rights within those basins was something that you thought was unprecedented, or to use your words, unique, correct?
It was.
Okay. And you believe it was the state engineer's obligation to determine whether water was available, whether there was conflicts with existing rights, and whether a proposed use threatened the public interest, correct?
I think that was my testimony.
And you think that the state engineer would not have made those decisions unless he was convinced that the decisions were supported by substantial evidence in the record, correct?
I don't think it's appropriate just to read in the deposition of a deponent. If he wants to impeach him, fine, but I don't think you just ask him questions and answers outside of the impeachment context.
Your Honor, I'm asking the questions.
Are you quoting from the deposition?
I am in part I am. Yes, I am, Your Honor. So I can reword it, and then if he doesn't agree with me, I can show him the deposition. But
Your Honor, respectfully, you can't just read in a deposition. If you want to use, he's not a party.
well, Your Honor, this is
Oh, hold on.
Okay.
It's not contradictory testimony. He's not impeaching him. He's just simply reading from a deposition that was given. That's, if it was a party, I would agree.
Go ahead and pose questions.
yeah. Your Honor, I'll just for the record state that there have been numerous times that counsel for the state has done exactly that, read a deposition of a non-party into the record. But I'm happy to rephrase it. I'm happy to rephrase it.
Go ahead.
As for the record, I don't think I read non-party depositions into the record without impeachment.
The record will speak for itself.
Next question.
Mr. Whittemore, state engineer would not determine that there was water available, that it didn't conflict with existing rights, and its proposed use did not threaten the public interest unless he believed that that decision based on those criteria were based on substantial evidence, correct?
I said, but may I explain, Your Honor? The answer is yes, generally, because I think that's exactly the standard that I've previously testified to, that I think that all decisions of the state engineer have to be based upon substantial evidence, and the standard that you just described was the one that I've described.
Right.
So the answer is yes, generally correct.
And Mr. Whittemore, the state engineer never told you specifically that there would be a reordering of priority of water rights as was demonstrated by the Sullivan decision, correct?
Objection, mischaracterized the Sullivan decision, Your Honor.
Overruled.
The state engineer never told me that he was going to reorder the priority of water rights in Coyote Springs.
That's your testimony.
Yes, sir.
Okay. Now, having gotten that part aside, completed, I want to turn to party now.
Okay.
All right. So you can just set aside your deposition for now.
Okay.
So let's turn to exhibit 529, please, if we pull that up. All right. Mr. Whittemore, I just want to spend a moment with you on the party payment history. This is a document that's been previously submitted.
Yes,
And is this a document you recognize in general?
I've seen it before. I haven't reviewed it. I don't think I reviewed it in the context of my deposition, and I don't think we've talked about it before.
Right, we haven't talked about it before, but is this a document or something similar to a document you would have seen during the course of your time when you were manager for CSI?
Your Honor, the document has dates in 2013.
Yeah, my question was, during the time that you were manager for CSI, would you have seen documents similar to this where there was a tracking of parties' payment history?
In the context of this document, the answer is I've never seen this document. I don't believe I saw this document because, again, it has stuff on it from 13, 12,
Right.
11 when I'm gone. But let me see if I can help His Honor. I would certainly have been aware of the payments made by Party because it was essential for our ongoing operations to receive the payments on a timely basis. So yes, I would have been aware generally of the payments. I don't know who prepared this or how they characterized it. I don't know who prepared it. So
Do you know, does the name James England sound familiar to you?
yes, of course.
Who's James England?
James England was our sort of second in command accountant type underneath Jim Harris and Brad Mommer. Brad would have been the CEO in charge of these types of accounting functions. Jim Harris would have been the first or the sort of the top accountant, then James would have been the second.
Okay. Did you believe James England to be a competent professional at the time that you worked with him at Coyote Springs?
Yes.
Okay. I'll represent to you that James England or somebody under his direction and leadership typically prepare these kind of documents. I'll just represent that to you, okay?
Okay.
And you'll see that there's a column for month and there's a column for single family payments and other payments going across. I'm going to focus you on single family payments and then the cumulative payments.
Okay.
And you see there's just in April 5 and through 06 and 7 and 8 and 9, that would have been all the time, all during the time that you were with Coyote Springs, right?
Yes, sir.
And there would have been then payments made by Pardee under a schedule, depending on the options that they were exercising and what they were doing under the party agreement. Is that correct?
That's correct.
Okay. And you can see the single family payment column. This runs down through 2009 when you were there. And if you turn the next page, 02, you'll see that the total is $84 million. You see that?
Yes, sir.
Is that figure consistent with your experience with Pardee in terms of the payments that they would have made for those single family resident payments under the Pardee and CSI agreements?
Yes, those numbers match.
Okay. And then if you go over to the cumulative payments, that last column there, and we just we know that it's more than just the single family payments. We can see the headers across the top there about what other payments were being totaled there. But if you go all the way to the cumulative payments made, then you turn the page to page 2, you'll see there's a $150 million figure there at the bottom.
I see it.
Is that consistent with your understanding of the cumulative payments roughly that Pardee would have been making under the Pardee and CSI agreements?
As to the point in time that I left, there would have been an accounting that would have added all of the payments that Pardee made and correctly identified within categories. I can speak to everything through probably maybe the end of 9.
Okay.
Don't know about 10 so much, or clearly 11, 12, 13. But if your point is that we were receiving from Pardee payments for multiple things and they had to be categorized correctly, the answer is yes. And the amounts seem to jive with what we would have received on a cumulative basis.
Okay, thank you. Now, the party agreements, they specifically reference, as we saw just for a little bit of time that you were being questioned today by council, they reference the water permits and the water availability. We saw some of those provisions. So I'd like to pull up those exhibits. Let's begin with exhibit 3302. All right, we're gonna go 3302. And I'm sure you recognize this document, don't you?
Yes,
What is it, just in general?
this is the option agreement between Party and Coyote Springs regarding the sale of the property which Party is interested in purchasing at this time.
Okay, and what's the purpose of this agreement, just in general?
It provides to Party an option to purchase real property and provides for joint escrow instructions if they pursue and exercise their option to do so.
Right, and you already mentioned it's a $66 million purchase price under this agreement?
Under this agreement, yes.
Okay.
And then it's further modified pursuant to the option agreement to get to that $84 million number that we just talked about in the prior exhibit.
And let's just go to your, just so you can just see it. Let's go to your signature page, it's on page 48. Hunter, just pull that up for Mr. Whittemore.
Yes, sir.
That's you.
That's me.
And page before that, that's going to be a couple senior vice presidents from Party Homes of Nevada.
Yes, Party Homes of Nevada. William Bryan was the senior vice president. The other signature is John Lash.
Thank you. All right, let's take a look at 0028, please. We get there. And we probably ought to start at 0028, just, you probably know this document so well, you don't need to be oriented, but just on 0028, you can see that the header up there, number 11 is seller's warranties, representation and covenants. That's the
correct.
section we're in.
That's good.
Okay, then we'll go over to subsection K, which is 0030, and come down to the second sentence here. Similarly, seller shall use its best efforts to obtain any necessary water rights and water service for the entire site in a timely fashion to enable the buyer to purchase the purchased property and option parcel in accordance with the schedule contemplated hereby. So, Mr. Whittemore, we've heard some reference to good faith efforts. It was the best efforts that you were representing to Party that you would pursue in order to secure all necessary water rights and water services in this section of the agreement, correct?
Correct.
Okay. All right, let's now go to page 010 of the same agreement. And again, just to orient you, we're now in subsection B in the kind of the one top third of the page, and now we're at Romanet 3, and got some introductory language there in Romanet 3, except in the event buyer exercises the entire option or its option to purchase the entire option property. Seller shall have provided evidence reasonably acceptable to the buyer that water service is readily available to the portion of the entire site, which includes the property being purchased at the applicable close of escrow. Why were you making this particular representation to Party?
Objection is to the term representation, Your Honor. I don't think it's in the representations portion.
Why were you making this statement to party?
I was agreeing in Romanet 3 that I had an obligation, CSI had an obligation, Your Honor, I'm sorry to say CSI had an obligation to provide evidence reasonably acceptable to buyer that there was going to be water service to the portion of the property that they were purchasing. In other words, if they purchased X, you needed water for X. If they were purchasing Y, you needed to have water for Y. And we had no obligation if they decided to exercise their option and purchase the entire property, because then it would have been their obligation. We would have been out of the operation. This is what I was talking about with counsel for the state, that I needed to stay ahead of the purchases of party to buy properties.
Okay. And so this was a condition preceding to any purchase. Take a look at subsection B. It's a condition preceding, right?
It's each of the things that are there are conditions preceding, and this Romanet 3 is within that category.
Okay. Now, if we can take a look at, I want to just orient you again, page 0012. This is concerning escrow. You see that? Number 4.
Okay.
Yes, turn the page. We'll go over to subsection B, and I want to turn your attention to Romanet 3. And actually, before we do that, up in B, the settlement date shall be scheduled to occur on the date, which is 5 days following the last to occur of, and then it has some Romanet subsections there. Do you understand settlement date to be the close of escrow?
Correct.
Okay. So this was a condition for closing escrow, Romanet 3. Buyer's receipt of satisfactory evidence that seller has sufficient water rights with respect to the water service for at least 1,500 production residential property acres within the portion of the entire site. And then it goes on with other language there. My question for you is, was this a significant or important condition for closing escrow for you and for party? You meaning CSI.
Yes.
And why is that?
Because without it, party would not have proceeded with a closing unless they were convinced that we'd given them evidence to show that there was water that was going to be provided pursuant to a mechanism to deliver water to their homes.
And Coyote Springs would have been the one providing that evidence to party?
Yes, sir.
All right. Okay. Let's now turn to 023. Same thing, I'll give you a little bit of context here. Let's go to 022. The heading number 9 is exercise of option to purchase of option property. So this part of the agreement addresses the buyer or party's obligation to exercise its options or opportunities to exercise its options.
This is the provision that says this is the process by which you exercise it. You have this right. Now this is how you're going to exercise it, and this is what you should do.
Okay. So if we go to D now on 0023 at the very bottom, notwithstanding anything here to the contrary, buyer's option shall automatically terminate unless buyer has exercised its option for one or more of the option parcels, consisting of least of an aggregate of 200 acres per year, commencing on the date, which is 5 years after the opening of escrow, determined on a cumulative basis. What does all that mean?
It means that what traditionally you do with respect to options is to say you can continue to have a continuing option if you do X within the time frame that's established. Here it is. You must purchase 200 acres per year, and you need to get to 1,000 acres. Otherwise, you lose the option.
Okay. And then that subparagraph continues, notwithstanding the foregoing, the minimum requirement for any year shall be suspended and all subsequent time periods shall be extended by the period of time equal to such suspension. If and to the extent that water service is not available for the option parcels for which the buyer is scheduled to exercise its option pursuant to the phasing plan. Mr. Whittemore, can you explain what's being expressed here, please?
Yes, that notwithstanding sentence basically says your obligations are going to be told, TOLLED, pursuant to the, not TOLD, sorry, told pursuant to the agreement of the parties that says if you don't have water, and you can't show me that you don't have water, then I don't have to buy land, and my obligation, I get to continue to have my option because you didn't perform. And if I want to exercise my option, I'm not going to be, the option is not going to be terminated because there's been an intervening event, which is you didn't show that the water was available.
And Coyote Springs has then an obligation to provide evidence of that water availability.
If it doesn't, it's not, it's an obligation if you say, we want you to exercise this option, but if you didn't, yeah,
Then they
wouldn't perform.
Then they wouldn't have to exercise their option.
That's correct. But parties' obligation would be told, and they could exercise it in the future once you showed them that the water was there. They didn't lose it.
So this was a 2004 agreement. Then the agreement was amended, as we all know, in 2005.
Multiple times, yes, sir.
And beyond that as well. But let's go to the 2005 amendment and restated single family agreement. That's exhibit 172. All right. And I just want to I'm not going to read all these back again, but I just want to just note a couple of things. One, this agreement takes now the total purchase price to 84 million.
That's correct.
Okay. And then just to orient you, let's go to 008. This is in 2005. And you see very bottom contingencies. So we're in the very, very bottom. We're in the contingencies section.
Yes, sir.
And now I'm going to take you over to 001. Romanet 2. I'm not going to read the entire thing to you. The judge can certainly read that, or anybody else can read that, but I'm going to take you down to the very last sentence of Romanet 2. Buyer acknowledges. You see that?
Okay.
Buyer acknowledges that it has received satisfactory evidence.
Romanet 1.
Yep, Romanet 2.
Time out, that's the engineering.
We're on page 001. 0011. Yeah, we're on 0011. Sorry, I probably said 001. Pardon me.
There you go.
There we go. If we could just go down to the last sentence of that Romanet 2.
Got it.
You with me? Okay.
Yes, sir.
Sorry.
Yes.
Buyer acknowledges that it has received satisfactory evidence that water service is readily available to serve 1,500 production residential property acres in Clark County. So we saw where that was a contingency or a condition preceding, and now in this agreement, do you read this as party acknowledging that CSI has actually provided evidence or proof of the water services that had to be available for them to exercise their option?
Objection, this characterizes the document, Your Honor, doesn't say anything about proof.
Say that again.
It doesn't say anything about proof. The question says provided evidence and proof.
So that's what it says.
I'll strike proof. So this was would you agree then that this provision reflects that CSI has provided the evidence of the water services that were required under this in the 2004 agreement?
That's the position I would take as CSI, that that statement acknowledges that they cannot defer or suggest that there isn't been a satisfactory evidence provided to party that says that water service is available. So
Okay.
I think that's fair.
And that evidence would have included permit 46777, the Nevada Power permit, correct?
Yeah, I would assume so.
Yeah.
Is that fair?
That's fair. That's in 2005, you got that permit in hand,
Right.
correct? And you're actually at least representing to Pardee that you've got that permit in hand, and that's part of what you're providing by way of evidence. Is that correct?
I would assume so, because again, party's counsel is going to be looking at all of those things, and I would say to the court, I would assume that party said you have 46777, which is this base permit, yes, and you're making all these other efforts, yes. Is that satisfactory evidence to me as party that I can proceed with some assurance? Yes, that's what they're saying to me.
Okay.
That's what I'm assuming they're saying.
Okay. Let's turn to exhibit 3363, please. This is going this is going to be another party exhibit 3363. Got to figure out where all my documents are. All right. This is a document that we've talked about before, haven't we, Mr. Whittemore? Do you recognize it?
I recognize it. I know that it was, I think this, if we go down to the footer again, you'll see it's Carl's document, yes.
Okay, and you know what? I don't
And
know.
did I execute it?
Yeah, let's turn the page here. It's just 2 pages. Let's turn to the next
Yes,
page.
thank you.
Yeah, you executed this document, and in fact, I don't know that we have, but anyway, any event.
It's not admitted.
All right, well, then I'd offer exhibit 3363, Your Honor.
The base counsel.
Yes. Yeah.
No objection.
All right, Mr. Whittemore, just very quickly, just in general, what is this document? You said you recognize it. What is it? What is its purpose?
The purpose is to establish as between Coyote Springs and Pardee, who's going to pay what for the initial mitigation costs for the price associated with delivering mitigation water for the recovery of the Moapadace. And this is a way of us being Coyote Springs, getting Pardee to pay for a portion of the mitigation water.
Okay. And Mr. Whittemore, if you take a look at the fourth whereas clause,
Yes.
the CSI and you as the manager of CSI represented to Pardee that CSI owned 4,600 acre feet of water rights, and then you set forth the 2 water permits there, correct?
Correct. Those being the ones that we previously talked about this morning, being the modifications of 4677.
These would have been the progeny of 46777.
That's correct.
Okay. Direct your attention now to trial exhibit 177, please.
I think we should go ahead and take our afternoon recess now, and we can be.
Okay, thank you, Your Honor.
We can be 20 after 3. Okay.
All right.
Looks like we'll be back here 20 after 3. I believe that's what he said. 20 after 3. Yeah, it's 3:06. Thank you for tuning in to W4Nevada. You're watching W4Nevada Live with Matthew Winterhawk, and we are in continuing day coverage. Afternoon, day 16, Coyote Springs, LLC versus State of Nevada. We'll be right back after this. Thank you.
in my bones turns to hope. I was running thin. You knew my name like a hand on my back through the rain. And I breathe again. When I lean, you meet me there. I'm never lonely when I've got you. I'm never lonely. You pull me through. Never lonely. You pull me through. I'm never lonely when I've got you. Hard days left marks on my skin, but your mercy comes like morning wind. Every cracked up thought, every small despair, you lay them down right over there. And I breathe again. When I lean, you meet me there. I'm never lonely when I've got you. I'm never lonely. You pull me through. Never lonely. You pull me through. I'm never lonely when I've got you. When my faith runs low, you stay. When I lose my way in the hollow space, you stay. And I'm woke up to the screen glow, cold news on the floor. Somebody missed the sunrise. Somebody knocked on heaven's door. I held my breath for a moment, then I felt that gentle grace. One more day in my hands now. One more reason to say, maybe the road got rocky, maybe the rain came down. Every scar got a story, every loss turned me around. What looked like a broken season turned to gold in my chest. So I lift my hands higher for the breath in my chest. Thank you, God. Thank you, God. Thank you, God, for another day. Thank you, God. Thank you, God. Thank you, God. Thank you, God. You turned my hurt to praise. Oh, praise. Seen folks chasing a shadow, seen folks fold in the dark, seen a smile hide a burden, seen a bruise leave a mark. But the hard times taught me mercy, how to love what I got, how the little things matter when the whole world stops. Maybe the tears were holy, maybe the weight was kind. Every closed door saved me, every note came right on time. What looked like a heavy burden made my heart understand. If I still got tomorrow, I got a blessing in my hand. Thank you, God. Thank you, God. Thank you, God, for another day. Thank you, God. Thank you, God. Thank you, God. Thank you, God. You turn my hurt to praise. Oh, praise. What they call bad, you made it good. Life is a gift, and you gave it to me. Some don't wake up this morning, some won't see this light. So I hold this moment gentle, like a flame in the night. Every scar, every lesson, every tear that fell, you were writing my healing, even when I couldn't tell. Thank you, God. Thank you, God. Thank you, God, for another day. Thank you, God. Thank you, God. Thank you, God. Thank you, God. You turn my hurt to praise. Oh, praise. What they call bad, you made it good. Life is a gift, and you gave it to me. Thank you, God, for the breath in me. Ooh, thank you, God, for what I get to see. Ooh, thank you, God, for everything, for the life you gave, and the song I sing. Thank you. I seen the rain on the window, I seen the bills on the chair, I seen the tear in the mirror, still you were there. They called it loss, called it trouble, I called it a lesson in disguise. What looked like the end of my road was mercy in my eyes. So I lift my hands up for the breath in my chest. Every hard night changed me, made me see your best. Thank you for another day. Thank you for another day. Some did not wake up, so I praise you anyway. Thank you for another day. Thank you for another day. Even the bad turned gold when your love made a way. Thank you. I used to curse what I couldn't hold, used to fear what I couldn't see. Now every scar on my spirit feels like proof you care. carried me. What broke me taught me tenderness. What bent me taught me how to bend. And every door that stayed closed saved me from where I would've went. So I lift my hands up for the dawn on my face. Every hard thing mattered, every wound had grace. Thank you for another day. Thank you for another day. Some did not wake up, so I praise you anyway. Thank you for another day. Thank you for another day. Even the bad turned gold when your love made a way. If the road gets dark again, I won't let my heart complain. I know joy can rise up out of sorrow and rain. You made beauty from ashes, made a song from my pain. So I'm singing in the morning, saying your name. Thank you for another day. Thank you for another day. Some did not wake up, so I praise you anyway.
You'll notice that I've turned the audio off on the music. W4Nevada Live, tuning back in to afternoon session, afternoon break. Harvey Whittemore on the stand, day 16, Coyote Springs LLC versus the state of Nevada. I don't know why they look like they're answering questions and I have no audio feed. Just give me a moment to figure this out. I'm not sure they're back in session yet. Yeah, the judge isn't there. Okay. I was like, whoa, what's going on here? And that's the reality. Been watching this for 16 days, going on 5 weeks. And in the background, we're fielding news stories and putting out anything and everything that we can to make sure that Nevada is the most informed 17 counties, period. Thank you so much for tuning in. You're watching W4Nevada Live. My name is Matt Winterhawk. 17 counties, not just 2 in a sports book. We the people, we the press. Thanks for tuning in.
Order, start the June session.
Right, Stephen, please, we're back on the record. Witness is retaking the stand and you may resume.
Thank you, Your Honor. All right, Mr. Whitmore, just before the break, I was turning your attention to Exhibit 177. We're going to pull that up. This is a document you recognize, of course, Amendment 1 to the party agreement, correct?
Correct.
All right. Let's just turn over to one sentence. I'm not going to read all these paragraphs. The judge has seen this many, many times. It's been read to him many, many times. Let me just focus you on one sentence. 004, Exhibit 177, and it is number 12. That first sentence. Commencing August 1, 2006, and continuing so long as the agreement remains in effect, buyer shall pay to seller a monthly water commodity charge in the amount of $150,000. So that is party paying to CSI a $150,000 monthly water commodity charge, correct?
Correct.
What was the background behind that? Why was party and CSI entered into an agreement where part of the agreement provided for $150,000 a month water commodity charge?
It was part of the negotiation to advance our interest in having resources to continue to develop the water facilities. So it was a way of generating additional money.
Okay. And there was negotiations at the time concerning this $150,000 a month charge?
Yes.
Okay. And then would there be subsequent discussions and subsequent continuing negotiations concerning this $150,000? a month charge? Do you remember that?
Well, we wanted to, again, generate additional monetary resources so that we could continue to do the things necessary to make Part E want to exercise its option. And at the same time, we were putting additional money in. So we being CSI.
In your negotiations with a party, did party express that this $150,000 monthly charge was fair or was appropriate? You remember that?
Well, I don't think they would have agreed to it if it hadn't been, fair to both sides. I mean, in all negotiations, both parties need to believe that it's fair and reasonable. Otherwise, you don't do the deal.
Both parties have to believe that they're getting value.
True.
Okay. I want to take you to an email exchange concerning this monthly commodity charge. Okay, and that's going to be Exhibit 531.
Okay.
I'm not going to, again, read the whole thing to you. I'm just going to point out just a couple of things. And I'm going to actually focus your attention on the first two sentences of the email. But this appears to be an email from Brad Mommer. What was his position at the time?
Brad would have been CEO, manager of some level of entities.
Okay. And do you see the date, January 30th, 2010?
Correct.
And remember in your mind that the amendment number 1 to the party agreement was dated in July of 2006.
Correct.
Just to kind of keep you oriented. About
Correct.
three and a half years later or so.
Sure.
Okay. And then it goes to John Lash. We've seen his name multiple times before at party.
Correct.
He's a senior officer, senior official.
Correct.
Okay. You're copied on that. You see that?
That's correct.
Okay. You see it's what we've been talking about, this water commodity charge.
Correct.
Okay. And the email from Mr. Mommer, just the first couple of sentences, as a follow-up to yesterday's conference call, Harvey asked me to pull my notes regarding the water commodity charges added to CSI-PHN SFH Amendment number 1, period. By the way, that's just what we looked at, correct?
Yes.
Okay. At an accounting level, and in order to support the agreed upon amount totaling $150,000 per month, I created a simple analysis, which I have reattached herein. And then I'll represent to you subsequent pages in this email. There's an attachment of an analysis.
Okay.
Okay. So is it the case that Party and CSI entered into this amendment number 1, part of which included this monthly water commodity charge, and that charge continued all the way up until the date of this email? Is that your memory?
I assume so. Yes.
Okay. And then it's addressed again here
Yes.
in this email. And then if you look at the very last sentence there or paragraph, Harvey asked me to send this analysis to everyone in preparation for next week's meeting. You see that?
Yes, sir.
So then apparently there was a meeting on this that maybe involved other subjects, but it would have included as well the monthly water commodity charge.
Okay.
Okay. And so is it your memory that even after that meeting, then the party continued to pay the $150,000 a month?
Don't have any specific recollections.
Okay. But just based on this email here, is it your understanding then that there was a meeting and at least that subject was discussed and addressed?
Again, without reference to a specific document, I can't imagine that we wouldn't, because at the time, I assumed that we had that meeting. It wouldn't.
Yeah.
It would surprise me if we didn't. Let me put it that way. Is that fair?
The memory of it.
No, I do not.
You're looking at the document and thinking, well, the email says that we're gonna have a meeting, and I'm assuming we had a follow-up meeting.
Yes, sir.
Okay. Now, just knowing party, as you testified before, very sophisticated party, correct?
Yes.
They were at the time one of the largest home builders in the Western United States.
Correct.
And knowing party as you have, as you testified previously, Do you believe party would have agreed to pay many millions of dollars for water charges if the water permit rights were somehow speculative or unreliable?
Fiction foundation, Your Honor, also speculation.
Did you say his understanding?
Party was a sophisticated builder who knew about the importance of the water development program, which we were in the process of doing every day. They would not have continued to do what they did unless they believed in the project along with CSI. They were a committed partner. As a business partner, they would not have expended capital unless they believed that we could succeed.
And that would include the reliability of the water rights that they knew about at least, correct?
Yes, it would have included everything that we were working on, traffic, you name it, water being critical.
Yep, okay. Now, we have talked about the Southern Nevada Water Authority purchasing the $25 million, the water rights from CSI.
Correct?
Correct. I'm not going to replow all that ground, except just to say that you took comfort in the fact that Southern Nevada Water Authority was buying those water rights, correct?
I was happy that they did, and I believe that they agreed with CSI that those water rights had significant value.
That's the reason they paid $25 million for them.
Correct.
Okay, and you believe the CSI was pretty sophisticated and had a pretty good understanding of what water was available for development in the aquifer.
As I've testified to Council, Your Honor, I thought that there was a significant resource in the carbonate aquifer. We just didn't know the amount. Yes, sir.
Thank you. Now, council had addressed with you today some credit facilities involving Wells Fargo, and I'd like to turn your attention to that subject. Okay.
Okay.
Now we know, just by way of background, we know that Wells Fargo extended a $30 million credit facility to CSI in 2005, right?
Okay.
And that's correct.
I believe so.
Okay. And then the loan increased
Subject to check.
Yeah,
I mean,
yeah. And I'm gonna let you take a look at those.
All right.
I'm just gonna lay the foundation on
Okay.
this. And then in 2007, that credit facility increased to $150 million. You remember that?
Generally,
And there were other lenders that were brought in addition to Wells Fargo.
it was a syndicated loan.
Syndicated loan, right? Okay. Including national and international lenders. You remember that?
I don't know international, but I know for certain it was a syndicated loan and it was designed to expand the credit line.
Okay. And Mr. Whittemore, just given your long experience in businesses and as a lawyer, you would agree that banks are heavily regulated, wouldn't you?
Yes.
And you would agree with me, wouldn't you, that sophisticated banks are not going to accept collateral for loans unless the collateral has real value?
As a general proposition, yes.
Wells Fargo loan documents, you may recall, included provisions for lot sales reports and unit closing reports. Do you recall that?
I would have put that in my document, so I imagine that the names.
Okay. And if you have, and a sophisticated lender like Wells Fargo would not be putting in those kind of provisions, that is lot sale reports and unit closing reports, unless they actually believe that the development was going to come to fruition.
I'm sorry, calls for speculation. Your Honor. You can please answer that.
I don't understand his understanding.
I think that they would have put that provision in with respect to all the collateral. I don't know if it was just limited to Coyote Springs. I don't know that it wasn't cross collateralized with Sino projects. So I don't know specifically what the pool of collateral was. So I'd have to look at everything. And does that apply just to Coyote Springs or does it apply to California operations? I'd have to look at the document.
With the cross collateralization provisions and what all the collateral was. My question just really went more to, here is a document that includes lot sale reports and unit closure reports.
With respect, may I ask this question?
Yeah.
With respect specifically to Coyote Springs?
Yes,
Okay,
yes.
then,
With respect to Coyote Springs, I'll make that
Okay.
representation.
all right,
Okay.
thank you.
And the bank wouldn't include those kind of provisions unless they believe that there would be houses being built, correct?
Question calls for speculation.
Allow to state his understanding of the
They-
context.
They would have, any lender worth its salt would have included things that they anticipated to happen to ensure that they got their share of the improvements and or the sales that were being made with respect to the collateral that they were loaning on.
Right. I mean, that was one of the purposes of the loan, was to assist financially in the development of Coyote Springs, including the building of homes, correct?
Question calls for speculation.
Overruled.
Again, all of the loans that were made would have been designed to help facilitate the successful development of Coyote Springs. I mean, that was the purpose. Yeah, I'm confident that the documents reflect what it says you can and can't do.
All right. Let me go ahead and, I'm gonna pull up the credit
Facility?
documents now. Yeah.
Okay.
Let's go ahead and go to exhibit 534, please. We're gonna start at 769. All right. It may have been a while since you've seen these documents, Mr. Whittemore, but I'll give you just a second. If you could just blow up enlarge the first paragraph there, Hunter, just so that Mr. Whittemore can just get a feel for that. Just let me know when you're finished reading that, and I can continue on, but I want to get you oriented.
Okay.
What do you understand this document to be?
Well, it's the revolving credit agreement between Coyote Springs and Wells Fargo that talks about a $30 million secured revolving credit facility, which means that there has to be some sort of security that would impose, like a deed of trust, all sorts of security agreements with respect to other collateral.
All right, so this is the $30 million credit agreement with Wells Fargo in general.
Correct.
Okay, and let's just take a look at your signature page. Let's go to page 863, please, or 534, 863.
Mhm.
That's you,
That's correct.
right?
Mhm.
And then there's I guess Kathleen Sloat, who is the senior vice president for Wells Fargo, and the commitment amount is $30 million.
Yeah, that's not Kathleen Sloat's signature, and obviously they misspelled my name. I corrected it, but yes.
So somebody's signing for both of you, and
Well, no, it's my signature, but it's not Kathleen Sloat. Somebody, I think it was.
oh, it says 4. I see what you're
yeah.
saying. Yes, 4. Okay.
Okay.
Your Honor, may I have just a continuing relevancy objection on these loan documents, please?
Sure. All right, let's go to 898, please.
And the continuing relevancy objection is overruled.
They continue to be overruled.
Yes.
Okay, let's go to page 898, please. We're still here on the $30 million loan document. Just going to focus your attention on a couple of things here. This is an exhibit K to that agreement. If you could just enlarge the first paragraph there, Hunter. And just let me know when you've read that, Mr. Whittemore, you're ready to talk about it.
Sure. Mhm.
Okay, so this is a covenant that borrowers are making with the lenders. Is that correct?
Well, what it's doing is saying that this exhibit, which supplements the revolving credit agreement, is we're going to say that all the things that we say in this are going to be true and correct.
Yeah, and that's going to be a covenant and an agreement.
A covenant within because it's an exhibit, it's adopted by reference within the revolving credit facility.
Okay. Did you consider this supplement to be an important part of the loan document at the time that you negotiated it or were involved in it?
It was created for the purpose of ensuring that we could get the credit facility. So all of the terms and conditions of the agreement themselves are extremely important. The $30 million was important.
Yeah, $30 million loan is not insignificant. At least it wasn't to you or Coyote Springs at the time.
No,
Okay. If you can come down now to about 2/3 of the way down, it says Coyote Springs collateral. You see where I'm at?
yes, sir.
Okay, great. Let's blow that up. I'm going to direct your attention to, you're welcome to read A through D, but I'm going to direct your attention to E. All right?
Mhm.
So taken together, Coyote Springs collateral shall mean all rights of Coyote Springs under permit numbers 70429 and 70430 filed with the state of Nevada Division of Water Resources, and all water rights, whether vested, permitted, next page, or certified, in which CSI or any affiliate owns or hereafter owns any interest, and which water rights are appertinent to the entire site, whether in whole or in part, including without limitation Coyote Springs interest in Cane Springs. What were you offering as collateral to Wells Fargo for this $30 million loan in subparagraph E?
The specific water rights deriving from 46777 as changed under permit 70429 and 70430, and whether or not they were vested, permitted, or certificated, as long as they were pertinent to the entire site being Coyote Springs. And yeah, I mean, that's what it means. And then also includes any interest that we had in Cane Springs, i.e. those agreements that we talked about between CSI and Vidler.
Okay. And why were you identifying specifically the permit numbers?
Because as collateral, they should have, and I don't know whether they did, they could have filed something with the Nevada Division of Water Resources showing that they had an interest in those particular permits to put other people's on notice that you can't sell or mortgage or otherwise.
What does that mean the borrower and lender are doing? What is the significance of representations and warranties within loan or credit documents?
Well, representation is, as his honor knows, under Nevada law, representation is a statement that has to be taken as a matter of fact as between the parties if there's ever litigation about something. So if you represent, I'm 46, you have to be, you're representing that you're 46 and you can't challenge that when someone says, you said you were 46 years old. A warranty says that subject to the terms of what the warranty is, that you're in effect asserting the rights of a lender to say this is what you guaranteed to us, and was that true?
Okay, thank you. And let's take a look at subsection C of paragraph 5. You're welcome, if you'd like, to read the other subsections. I'm just going to focus you on subsection C for now.
Sure.
One of the representations and warranties that Coyote Springs through you made was adequate water is projected to be available to permit full development of Coyote Springs property on a timetable consistent with the projected development schedule, therefore, and consistent with the types and density of projected uses for such project. Why were you and Coyote Springs making that particular rep and warranty to Wells Fargo?
Because they were making a loan that's partially secured by the development of the project, and the development of the project requires certain water. So what we were saying is that the adequate water is projected to be available.
Thank you. Let's look now at the next page, 903, continuing with the additional representations and warranties. I'm just going to focus your attention on number 6 here under water rights, and I'll just read it to you. Coyote Springs currently owns approximately 4,600 acre feet per annum of water rights for Coyote Springs property, as permitted by the Nevada engineer, a true and correct copy of which has been provided to administrative agent. Let me begin with this question. Why would you have provided true and correct copies of the permitted water rights referenced in this section of the agreement?
Because you want to disclose that the terms of the permit are I cannot give to the lender anything that I don't have. And therefore, when I give them a copy of the permit that says you get 4,600 acre feet, you get 4,600 acre feet subject to the terms and conditions of the permit. I can't say you get to take 4,600 acre feet without regard to any rules or regulation of the state engineer. It's subject, it says it's subject to existing rights. So obviously that's a very important provision, is that you give them copies so that they can see that.
And after receiving the copies of the permits that you and CSI had provided to Wells Fargo, they went forward with the $30 million loan, right?
They did.
And they used those water permits, copies of which you gave to them, as collateral for that $30 million loan.
They did.
And you and CSI represented to the bank that CSI owned approximately 4,600 acre feet of water.
We did.
And that would have to have been the Nevada Power Water, right?
Correct.
That's permit 46777.
That's correct.
So permit 4677 and its progeny was used as collateral then for this $30 million loan, at least in part.
It was part of the collateral pool. That's correct.
Okay. Now let me take you to 0668. Mr. Whitmore, is this a document you recognize? Let's go ahead and just magnify the top paragraph there, if you would, Hunter.
Okay.
What is
That's
this?
it.
What is this, Mr. Whitmore?
It's a document that's required by the administrative agent in favor of Wells Fargo that basically says we're going to continue to provide and perform as required under the terms of the document.
Okay.
Under the terms of the loan. Excuse me.
And if you take a look, you'll see the date is September 8th, 2005. Do you recognize this as a guarantee in connection with the $30 million loan?
I believe it is, yes.
Okay, you can look down at recital A.
Yes.
See the $30 million?
Yeah.
Okay, thank you. And then you are here as one of the guarantors. Do you see that?
Correct.
And there's also Mr. Thomas Sino is here as well, correct?
The trust, correct.
And his trust, sorry, thank you.
Mhm.
And if you take a look at the line where your name is in all caps, Harvey Whittemore, an individual, paren, individually and collectively, jointly and severally. What did you understand that language to mean concerning your financial obligations under this credit agreement?
I was obligated personally to make sure that the $30 million was paid.
And so if it wasn't paid, the bank could come after you personally.
Agreed.
Okay, let's go to 676, please. You've got your signature there, Mr. Whittemore, correct?
That's correct.
Okay. So I'm gonna turn now to the $150 million loan, but just chronologically and just sort of to round out the picture. In between 2005 and 2007, there'll be a couple of more increases and adjustments in amounts. Do you remember that happening over the course of that time?
Over a course period of time, as I recall.
Okay. But I don't want to suggest that it went right from 30 million to 150 million.
Okay.
But that's why I'm going to go with the documents, okay?
Okay.
So let's now go to 439. Page 439. All right. So let's go ahead and increase or magnify that first paragraph again, just to orient Mr. Whittemore, because again, I know it's probably been a little bit of time here. Do you recognize this document and what's its purpose?
Well, it,
I'm on page 439.
thank you.
Yeah.
There we go. Yes, I recognize generally that it says it's an amended and restated revolving credit agreement for our entities and with Wells Fargo
Okay.
as the administrative agent and the lead arranger, i.e. they were the primary bank as in the consortium.
And they were the syndicator?
Yes.
Okay. So they're going to bring in other banks, which we'll see here in just a minute. But this agreement now adds some borrowers. Do you see that?
Yes, it includes the entities which were part of the underlying agreements. Correct?
Okay. And let's go to page 447 next. Okay. And on page 447, if we go to the very bottom, guarantor, and just highlight that and over to the carryover paragraph on the next page, Hunter and 448. The grantor there, you see the grantors there are jointly and severally, Mr. Sino and his trust, and if you turn the page, you as well.
That's correct.
You're the guarantors, is that correct?
That's correct.
And you continue to be jointly and severally the guarantors, right?
That's correct.
Was this significant by way of guaranteeing a $150 million credit line to you or credit facility to you, Mr. Whittemore?
I apologize for laughing, Your Honor, but $150 million is so significant. Yes, of course.
This is a big deal personally to you and from a business standpoint for CSI.
These are big deals.
Okay. Let's go to 455, please. And we'll just underscore how big it is because here's the $150 million total commitment route. Do you see that?
Yes, sir.
Okay. Let's go to page now 540. Mr. Whittemore, here's your signature on behalf of Coyote Springs Investment LLC. You see that?
Yes, sir.
And let's go to 543. And we have then your signature for 3 other entities as well. You see that?
Yes, sir.
All right. Let's go to 552. And this is what you were talking about, right? These are the banks that came in under the syndication.
Yes.
Okay.
And now I recall Bank of Scotland and
Yeah. You weren't sure, but now you see international.
I remember now.
Yeah. International banking institutions here.
Mhm.
So if you just walk through this list here, Wells Fargo Bank, the Bank of Scotland, Key Bank National Association, Redwood Capital Finance, Bank of the West, Nevada State Bank, and Shanghai Commercial Bank. In your experience with this loan and in other business environments, would you characterize these lenders as serious, sophisticated lenders?
Yes.
Okay. These lenders would take their credit commitments and their loans seriously.
Yes.
In fact, during the course of negotiations and drafting and crafting of this document, this credit facility, did both sides have lawyers and professionals and people who had a lot of experience in paying attention to the actual deal that was being done?
I would say so, yes.
All right. This is in 2007. And so in 2007, I know you took this seriously individually. You already said that.
Yes, sir.
And CSI would have taken this seriously. You've already said that because it was such a big deal.
Very.
And let's now go to 602. We're still within this $150 million loan documents. All right. And we've seen similar reps and warranties, but I want to just review what's in this $150 million loan document with you. And we'll go to section 5. If you could just highlight that, Hunter. And I just want to highlight really the first maybe half of it or so. And just like magnify maybe the first half of it or so. Or you can keep it that way, it's fine. That's fine. So, Mr. Whittemore, again, you and Coyote Springs are making certain representations and warranties in this document, right?
Correct.
All right. Let's go to the same subsection C that we looked at before. C is a rep and warranty that adequate water is projected to be available to permit full development of the Coyote Springs property on a timetable consistent with the projected development schedule, therefore consistent with the types and densities of projected uses for such property. Again, CSI and you through, or CSI through you are once again making reps and warranties about the adequacy of the water that would be available to secure this $150 million loan.
Objection to states the document, Your Honor. Doesn't say anything about adequacy of water.
Or rephrase.
You're making reps and warranties about, quote, adequate water. Close quote, aren't you?
Adequate water is projected. We
Yep.
need to keep
Right.
that fair. Yes.
So, let me just finish that out. I'm not suggesting that it's not projected. Adequate water is projected to be available.
Correct.
Same or similar
Same.
language that we saw under the prior agreement.
Very similar.
But nevertheless, making reps and warranties about water to these lenders, right?
Yes, sir.
And by this language, you were not suggesting, were you, Mr. Whittemore, that the water would be somehow unreliable or speculative in nature? Are you?
No, it's not there.
All right. You didn't believe that, did you?
I previously testified that there's an anti-speculation doctrine within Nevada water law, and we weren't doing that. We had a real project.
Right. Real project with real water rights.
As real, the answer is yes, because the 4,600 we paid money for, we thought that they were good, solid water rights. Solid is, again, solid as water rights can be in the state of Nevada, because as we talked about, they're all subject to existing rights, and we put that one to bed.
Right, but you weren't suggesting anywhere in this representation that we just read that the water was inadequate or unreliable.
No, sir, we would not have said that.
Mr. Whittemore, wouldn't you agree with me that if in fact in your mind, as you were negotiating this deal and when you were signing this deal, if you really believed that the water permits that you had or CSI had in hand were somehow speculative or unreliable, you would have disclosed that somewhere in these documents?
You could not have made that representation warranted.
Let's go to 603, please. Very similar language that we saw in the $30 million loan documents. Mr. Whittemore, now it's under heading 6. I'd just like to pull up maybe the first, 5 lines or so of that. And again, if you'd like to read the whole thing, please let me know. And I'm happy to have you read whatever you'd like to read. But again, Coyote Springs just was making reps and warranties about certain water rights, correct?
Correct.
Just like we saw in the $30 million loan.
Correct.
Correct? It was making reps and warranties that Coyote Springs owned approximately 3,600 acre feet, right?
Correct. It's been dropped.
Right, it's been dropped because there's 1,000 acre feet that went to the GID.
Correct.
Okay. So the GID was holding that for the use and benefit for Coyote Springs.
It would have been a it falls into the category of the quote being a bank right, and
Right.
you get a collateral on that. Separate entity, don't know that we could have provided direct collateral, but you could have provided collateral with respect to the beneficial interest. So I'm sure there's language somewhere in the documents regarding that.
And there is. And you reference, just like you did in the $30 million loan, that these water rights that you had were permitted by the state engineer, correct?
Correct.
So we know that these again are the Nevada Power water rights.
Would suggest so. That's correct.
Permit 46777
And its progeny.
and its project, yes. All right, let's go to page 1181, please. Right. Now, this is going to be, Mr. Whittemore, the guarantee on the $150 million loan. Just want to review it fairly quickly with you since it's going to be very similar to the $30 million loan. But do you in fact recognize that document or page 1181 as the guarantee for the repayment of the $150 million loan?
I do.
Okay. And you again see that you're listed individually there, Harvey Whittemore.
That's correct.
And once again, you're joint and severally liable,
Correct.
which means if the $150 million loan isn't repaid, they can come after Harvey Whittemore personally.
Correct.
Very serious deal.
Very.
All right. Let's go over to 1189, please. And we'll finish out this document by just looking at your signature here. And this time you're signing not in your capacity as a manager or an officer of CSI, but you're signing this individually, Harvey Whittemore.
That's correct.
Okay. Thank you. Okay. Turning back to something that council talked with you for just a minute about, that I'd like to turn to, and you and I had some time, I think at the very end of our time together about a month ago. That's the PGA and Jack Nicklaus.
Okay.
Okay. And you recall that the PGA signed a master agreement in March of 2005 for what you called the PGA Village.
Correct.
That was modeled after the PGA West in La Quinta, California.
That as well as the Florida.
Okay. And Jack Nicklaus had committed to design, I think, at least 3 golf courses.
He committed to, subject to, I don't know whether he committed to 3, but he had certainly committed to 1 individually. 1, we wanted to introduce Pete Dye as a joint. They had never done a course together, and we really wanted a Nicholas Dye course as number 2. And so I had talked with Jack about that, and he said yes, he'd love to do it. Had never done anything with him before.
And I think that you mentioned previously that bringing to the PGA and Jack Nicklaus on board was a big deal.
Yes.
One of those, I can't remember what kind of those turning points on the continuum or whatever we called it last time. We had a word for it, but it was important.
Yes, sir.
Okay. And it was important because these are world-class people and world-class organizations that are going to protect their brand. And if they're coming on board, that says something about Coyote Springs.
It does indeed.
Okay. Let's turn to Exhibit 165. Okay. Council spent a little time with you on this document. It's absolutely beautiful. We already started out, so we don't have to have you lay any foundation for it. It's already admitted into evidence. You know what this is.
I don't have it in 165.
No, it's
The state's version is in.
what number is it?
3346.
3346.
So it states 3346, and just for reference purposes, it's Exhibit 165 for CSI.
Okay.
So because my base numbers are 165, I'm going to refer to Exhibit 165, but it is omitted.
And you said defense 3346?
Yes.
Okay, don't have it in under defense either.
I thought that was,
If it's not omitted, we'll stipulate to it.
I thought it was another earlier.
I think it was.
Oh, you mean today?
Correct.
I have 3363. 333, yes, you're correct, I'm sorry.
That's all right. And 165 is omitted as well.
I'll admit 165 as well.
All right, so this is CSI's exhibit 165.
Yes, sir.
And well, I'd like to just have you turn to 005 of that document. And you were involved in the preparation, I gotta believe, of this document, this material. Is that correct?
Yes.
Okay. You note, or the brochure, or what are we gonna call this? Just the
Marketing plan?
marketing plan? Okay. You note there on the marketing plan here, Coyote Springs Investment LLC, and then you say it's an affiliate of Wingfield Nevada Group. And then you talk about a portfolio of companies and a portfolio of communities. And we've talked about Wingfield Springs. I think we talked about the resort at Red Hawk and these other ones. Are they all related? So maybe the best way to do it, maybe just start off with a better question.
Wait,
What relationship do these entities and these companies and these communities have to Coyote Springs Investment LLC?
they have common ownership interests. That they're owned by same people.
Okay.
So it's Tom. At this time, this is Tom and myself.
Okay.
And so the communities going down Wingfield Springs is the general location of the community located in Sparks. The resort at Red Hawk is the central core within Wingfield Springs. The foothills at Wingfield Springs is the property that was adjacent that I told you about. Purchasing from Tim Tucker and then selling that property. Coyote Springs obviously is the community that we're talking about. And Tierra del Sol is a piece of property on Pyramid Highway that was owned by the company.
Okay, so these are as described, portfolio of companies and portfolio of communities associated with Coyote Springs Investment LLC.
Yeah, they're sister companies, correct?
Okay, so this development was not your first rodeo for either you or for Tom Sino, correct?
Correct. Yeah.
All right. Now let's take a look at the next page I'd like to have you go to is page 8. And as council was talking to you about this, you had mentioned this idea, town away and a world apart. And does this express your vision here? We talked about that a little bit at the beginning of your testimony, but does this statement express your vision here, the town away and a world apart? Each town or village features a downtown hub, while a system of trails connect residents to parks and open spaces, as well as with one another.
Yeah, we're trying to build a community that's special.
Like have something there, right? Have a sense of place, a
Yes.
sense of identity.
That's what I described. Yes, sir.
Okay. Would you have used this marketing plan with, for example, the PGA and Jack Nicklaus?
Well, this would have already, the Bear Trail is a nomenclature for Jack Nicklaus. So this would have already, we would have already had discussions with Jack. I don't know that there's a reference in the document. I can't recall whether it's in this one or the next one that the PGA nomenclature is there. So again, all of those things, what we're trying to do is to update decision makers, relevant people in the Southern Nevada area. Might have used it with meetings with the governor's office, could have provided it to people at the legislature, just people like yourself, Governor.
Okay.
Okay.
What about to local officials, Clark County commissioners,
Absolutely. That's what I'm saying.
commissioners, you know, up in Carson City or whoever you're speaking to within the government, this could have been something you would have used or likely would have used?
In meetings, I don't know that we submitted it in public meetings, but in private, you would have had discussions. They would have asked, what's the status? Here's what it is. They're called takeaway pieces that you give to someone and they take them away, take them home, look at them for a while, throw them away when someone gets mad that they have too much junk.
Okay, so would have used it in connection with just people who are interested in the project, both governmental, business, investors, partners.
Don't know whether we did it with investors. Don't know that. I mean, at the time, Tom would have seen this. He would have, you know.
Yeah. Would this have been something available or shown to those in the state engineer's office, for example, as you were updating them on the project?
I don't know that I would have provided if anybody in my office would have provided state engineer, I don't know that.
Okay. Okay. 009. You continue on with the marketing plan. Call it Southwest, call it America, better yet, call it home. Would you agree with me that in order to call it home, you'd have to have houses?
Yes, sir.
Okay. Turn over to 010. Very bottom left-hand side there, Hunter, the paragraph just before the last paragraph, in addition, if you just highlight that. In addition to land assets, CSI holds 4,600 AFA of water right permits in the Coyote Springs Valley and over 25,000 additional water right permits within the region, with another 108,000 AFA of pending water rights applications. Those pending water right applications would have been those that would have been submitted in connection with ruling 1160 or order 1169, those pending applications before the state engineer.
Those 108 would have been the ones that were filed with, that we asked Herijet to do, that we then got the assignment from. So those would have, as I described it, those are the ones that we, quote, put over the top to guarantee that no one else could get water on top of our existing rights. And then the 25,000 is probably in reference to Tuffy Ranch and Geyser.
And the 108,000 acre feet, those would have been those applications would have been held in abeyance under order 1169.
Oh, they would have, yes.
Yeah, right. Okay. And the 4,600 acre feet, once again, those would have been permit 46777 or their progeny.
Correct.
Okay. Let's go over now to the right-hand column there. And again, the next to the last paragraph there, Coyote Springs is envisioned as the highest quality life cycle community in Southern Nevada, offering an affordable lifestyle and resort-like setting where families can live and work through each stage of their lives in an unparalleled natural environment. Because of accessible water, the community will feature a continuous valley of green with golf courses and natural system of parks, open space, and trails connecting residents and vacationers to the valley's greenway. So seems like access to water, the availability of water is important in terms of your marketing plan. Is that accurate?
Yes, sir.
Okay. Why would you want to emphasize water and the accessibility of water in your marketing plans?
People like to, even in a desert setting, like to see, you know, green associated with their, walking trails. You need sufficient water to grow the trees. To even in a desert environment, you need modest amounts. And as I indicated, we were trying to create a community that generated sufficient effluent to build a sufficient quantity of golf courses.
And then you, on the next page, to kind of underscore that point, you actually have a heading here, or the materials have a heading here entitled water. And it notes that, well, that's one of the very first questions that people ask is, where's the water coming from? And then you, in the marketing materials, I mean CSI, state that in addition to owning its own water rights, CSI is partnering with other regional water districts to bank water for specific purposes, providing ample, secure, long-term water resources to deliver potable and irrigation water to Coyote Springs, the Coyote Springs community. Once again, underscoring and emphasizing the importance of water within that.
Can we pull to the right page and write?
Did I just read all that and you couldn't even follow me?
No,
Okay.
sir, it was on the.
114.
It was my fault. I gave Hunter bad hand signal apparently.
All right,
Okay, there we go.
just read that. I'm not going to reread that.
No,
Just-
I got it. Yep.
And the only point here is, again, emphasizing within the marketing materials that Coyote Springs owns water within the Coyote Springs Valley and securing water within the region, right, for the purposes of building out this community.
I was correct. The first question asked in Southern Nevada is, where's the water coming from?
Good. Okay. Next page is page 16. Investment and partnering opportunities. Just that one sentence there under investment and partnering opportunities. Coyote Springs has received considerable national attention from various investors, builders, and potential homeowners. The increased attention that the community has received may be attributable to the way the project is uniquely positioned within its marketplace. That's the way that you or CSI marketing folks are describing Coyote Springs and the opportunities that are available in January 2006, correct?
Correct.
Why is Coyote Springs, or why was Coyote Springs then uniquely positioned within the marketplace?
Largest parcel of land within 60 miles of Las Vegas. Huge demand for land within the region. This was, again, very, very, very unique. And we thought that there were going to be sufficient water resources for us to do what we had planned.
Thank you. Page 024. This is an image that council showed you today. What does this depict here, Mr. Whitmore?
First phase of the development, single family homes, projected sort of orientation, golf course, storage lake for the water for the golf course, a resort corridor in the upper right hand side. Good representation of what might have made some sense.
Yep. And this was going to be for what you call phase one?
Correct. It's a sort of a projected layout.
What county would this be in?
Clark County.
Okay. And then we're just getting another look at it on the next page, on page 25. Again, just a little different view of, a little different image of what we're seeing here. Day one, phase one.
Yes, totally. You'd have to orient it. That's more towards the, if we change it, yeah. It shows driving, multiple different sorts of driving ranges over in the right-hand side right there where there's referencing right there. And then the resort corridor above it, right there. And then as you go to the northwest, additional resort corridor and homes all around the, various golf courses.
And so we've heard a lot in the trial about the phase one of Coyote Springs. And so the image that we saw just before on 024, this graph or this image we see on 025, those depict the phase one.
Yeah, general representations of conceptual plans.
Good.
Different. Those are different.
And then if you could go to the next page, you actually kind of lay out here in these marketing materials what phase one, the elements of phase one are going to be. Just take a quick look at that. Is that a pretty fair representation, at least as of January 2006?
So that answers the question of what was the ordering of the Nicholas.
Yes.
So Nicholas was the signature course, then Nicholas Dye, then a signature course designer to be determined, because again, I'm having lots of people call me saying, I want to do one, I want to do one, I want to do one. And then describing the things that we talked about, which are the PGA Village, but it also talks about Part E. And so they have a Part E guest builder program. So obviously we've settled on Part E, and then we talk about the CSI nursery, the medical facilities, convenience store. We had talked about what size the grocery store needed to be. So, Your Honor, all of this represents the fact that we pretty much identified a number of the potential partners.
And one of those potential partners is, as we've talked about before, PGA and Jack Nicklaus. Let's go to 029. Is this at least in part what the PGA and Jack Nicklaus was interested in doing? This PGA Village?
Oh, yes.
Let's go to 29, please. Yeah. We've heard
Nicholas,
this before, right? About the
yes,
PGA Village.
Yeah, Nicholas, Jack would not have been involved in, didn't have an interest in the PGA agreement. That would have just been CSI and PGA. But what we wanted to do was to, again, create this PGA Village, which had opportunities for resort play, people coming from all over the West to play this course, creating the golf schools, different things.
Okay. And this was going to be phase one?
This could have been included in the edges of phase one, yes.
Okay. And then just the last page I'll show you in this document is on page 31. This is a conception or a depiction of the clubhouse and event center.
Gorgeous, isn't it?
It's gorgeous, yeah. That's what it was designed to look like, and that's what you anticipated if things would have moved forward?
That took a ton of money to get to that point. The answer is yes.
All right. I'm not going to take you through any more of those pages. This can be set aside. Not up here in my notes. Let's take a look at this executive water rights summary that council had shown you. That's exhibit 3417.
Okay.
Okay. Make sure I've got that. All right, you've already laid the foundation and explained to the court what this document is and its purpose. I'd like to turn you to page 0003, please. Just to underscore the point that we've been talking about, let's see here. Actually, let's get started with the third bullet. It's not a bullet point. It's the first bullet point, but it's, I guess, the third dash. Fully entitled for up to 159,000 units, build out to occur over 75 years, with initial home sales estimated to begin in late 2009. So the projected life of this community was even beyond that of Summerlin. I mean, Summerlin, I think, is a 50-year community. So this is like 75 years at the time.
I agree.
Okay. And this summary states that, and again, the date of this is summer of 2008. And so
I'd like to correct you real quickly, counsel.
Please.
I've already identified that the summer 2008 is probably not accurate because it references some October types of agreements. So
Okay.
it's probably better to, probably should have reflected fall 2008 or.
Okay. I would just say,
Yeah.
okay,
Yeah,
fall 2008 time
yeah,
period.
sure.
That is fine with me. And I'm just looking at this, the third dash there about that, the number of units, the build out. And it also says that the initial home sales were estimated to begin in late 2009. You see that?
Yes, sir.
So if this is fall of 2008, that's about a year away.
Yes, sir.
And so is it your recollection and your experience with Coyote Springs that as of the fall of 2008, Coyote Springs was ready to start building and constructing homes within a year?
I thought, at this time, I thought we were well on our way to being able to break ground. Sure.
Okay. And in order to break ground for those homes, the water that you would have used for those homes would have been the Nevada Power Water, right? 46777.
Portion, yes.
Well, that would have been the water that would have been available then in terms of just like putting
Yes,
it to
just
use
a portion,
houses.
but a portion of the water rights is what I'm saying. You would have used.
Yes, thank you for that clarification. So you wouldn't have to have used 4,600 acre feet.
No,
But the water that you would have used at the time to start building homes and then actually put them into use with families in them would have been that 46777 permit water. Or the
yes, as long as we complied with the terms of their underlying use, which would have been that we would have expected approval of the mitigation plan, the pumping plans, all the things the state engineer required as part of the utilization of the water.
Well, and you were confident, weren't you, that you would have received those approvals in fall of 2008?
I believe that we would have succeeded in delivering on all of the obligations that the state engineer required for us to put that water to use in the context of this reference that we said initial home sales estimated. It would have mean that we would have been really having to pursue all of those requirements very, very quickly. Yes.
All right, but you must have been confident in order to make a statement like that homes are expected to begin home sales, not just even construction, but home sales were estimated to begin in late 2009.
I would have relied on the people at parties saying that they could have gotten stuff done. If we could have been in a position to deliver the water, again, all of the water was subject to it, as we discussed, Your Honor, subject to the requirement that we do the pump test and do the monitoring plan.
Sure. But nevertheless, even with those requirements, you still were making the representations or statements at least that we expect home sales to begin in late 2009.
Yes, sir.
Okay. And then the executive summary also says, again, just to underscore the point, that next dash, that there'd be plentiful water supply. As a result, there'd be golf courses and parks and amenities. We've talked about that before, right?
Yes, sir.
All right. And you then also in this executive summary highlight you and Tom and Albert Sino. Do you see that? The developers are deeply experienced in planned community and residential development.
Correct.
That was true of you and true of Tom and true of Albert Sino, wasn't it?
Correct.
Okay. And you note that you've got Wingfield Springs Resorts under your belt at a Hawkeye with 4,500 homes.
That's correct.
And Tom and Albert Sino, they'd constructed over 30,000 homes during their 70-year history.
That's the Sino Homes.
Sino Homes
is correct. Discovery and et cetera.
And you also note that if you go down one more dash, that the construction had commenced on the backbone infrastructure and it included the golf course and it'd be open for play by May of 2008.
Correct.
Okay. And then you also state here in the executive summary that over $300 million spent by CSI and its development partner Party Homes as of August of 2008. Best of your knowledge, that was accurate as of the fall of 2008 when this statement was made?
I believe so.
Okay. And let's turn then, if you can, to Next page. This just gives, all this is just gives us one more shot at phase one. The heading up there is phase one. Same sort of thing we talked about before, correct?
Correct.
So just repeated depictions of this phase one in multiple different marketing materials being supplied to those that you were handing out these materials to, right?
Yes,
And phase one was depicted in this manner in this executive summary. We saw it depicted the same way, or very similar to that in the marketing materials that we'd seen previously that we just reviewed, right?
correct,
And that phase one was always in Clark County.
correct.
Okay, thank you. Let's go to 0015, please. Just continue on with the executive summary, Coyote Springs water rights. And the materials note that Coyote Spring resides in Coyote Springs Valley water basin, and that it sits above one of the largest water aquifers in southern Nevada. You've talked about that before in your testimony, haven't you?
That's correct.
Okay. And then the materials say the company believes that it can service the entire community with water from CSV basin upon obtaining the appropriate water rights. You see that?
Yes, sir.
So at least as of this time, under the conditions and facts as you knew them at this time, Coyote Springs expected that the Coyote Springs water basin could provide all the water necessary for the community.
We still believe that the carbonate aquifer would yield very significant resources.
Good. And then if you come down two more bullet points, initial demand will be met with 4,600 acre feet of water owned in the CSV basin. That would be the 4677 permitted rights.
Correct.
And why in your view would this be, an important or a significant element to include in this executive summary? That the initial demand could be met with 4,600 acre feet that Coyote Springs already held under the Nevada Power Water Permit.
Because you needed to show that you actually owned the permits.
And would this initial demand have included phase one?
I don't know how many homes were in phase one, but assuming that you get, again, half an acre foot per home, if you have 2,000 acre feet, that would mean that you could have 4,000 homes.
Right.
Assuming that, again, it's a half an acre per unit.
Okay. Thank you. All right, I'd like to just turn to another subject now with you, Mr. Whittemore, and that is water wells. Okay? Water wells. Yep. We've been talking a lot about this permit 46777. And Mr. Whittemore, after CSI acquired that permit, it was, as we've talked about, required to put the water to beneficial use.
Correct.
Okay. And I believe you testified earlier that at no time during your tenure at CSI did the state engineer suspend or otherwise hold in abeyance CSI's obligation to put its water to beneficial use.
No, sir, they did not.
Okay. And it's my understanding that CSI and his partner Pardee, in fact, went to work drilling wells and seeking and installing infrastructure after the wells were drilled and doing other things to begin to put the water to beneficial use. You testified to that before.
It's true.
Okay. So both CSI and Pardee were interested, I assume, in finding water when it drilled those wells. Is that fair?
Yes.
You weren't just drilling wells in the middle of the desert just for kicks, right?
No, sir.
You were drilling wells to find water.
Correct.
Okay. Because that's what your permit allowed you to do.
The permit, to comply with the terms of the permit, you needed to conduct certain activities, one of which was to do the works necessary to put the water to beneficial use. The works, as I previously testified today, included wells, pumps, electrical systems, distribution systems,
wastewater treatment plants,
Yes, sir. I didn't mention that, but it's true.
water treatment plants.
True.
Uh,
Make it potable, correct?
Yes, thank you. So let me have you turn to, or let's turn to Exhibit 268, please. All right. Let me get there. Okay. First thing I'd like to turn to, to just give you just kind of a preview, I'm going to show you some of the well reports, well digger reports for the 4 wells that were drilled at Coyote Springs. Okay, that's where we're going. So let's go to 268, and now we're going to go to 371. All right. Now let's go ahead and just, if you could, Hunter, magnify the first third of this or so. Something like that. That's good. Okay. All right. Now this is for well number 1. And you'll see the permit number there. And I don't know if you've got these memorized, but would you agree with me that this is one of the progenies of 46777?
70430 is, and that's correct.
Okay.
May I ask a question, Your Honor? Is this, do we have a date on this?
Yeah, if you go to the very bottom, you'll see where there's a received stamp. Let me give you a date on that. Yeah. See it there?
Okay.
It's talking about May 26, 2005.
Okay, this is the representation that this is part of a larger document?
It definitely is.
Okay.
Yeah, I think this is like this came out of the state engineer's like files.
Okay.
And it's a very large document.
But is it included in the face page? Said it was a geotechnical report that Jason King had established. That if you go to the front page
Sure, yeah.
of this document,
Yeah, take a look at it. Yeah.
that this is prepared for Part E,
Right.
And it's 2012, which I'm no longer around, and then the stamp says 2017 by Jason King.
Yeah. And if we were to page through all these, I mean. The page I'm on with you is 371. So there's 370 pages between what I'm showing you. But I'll represent you. This came out of the state engineer's files.
Got it.
And was produced in this case.
Got it.
But it's very big. It's a very big.
But I didn't, you're not suggesting to me that I've necessarily seen these documents, right?
You may or may not have.
Got it.
In 2005, you were around.
Yes, sir.
2012, you weren't.
Correct.
Right.
That's what I'm trying to reference, how this with 5 was attached to a 12 and.
Yes.
Got
Part
it.
of a very large file of documents.
Got it. I remember that Lane Christensen was doing some well drilling for us. Yes, sir. I
Okay.
do recall that.
Okay.
Just for clarification of the record, is this document that we're looking at attached to the environmental report as the first page, or is it just a separate independent document?
I'm sorry, what's the question?
So the first page that was shown to the witness was the environmental report 2012, and I'm uncertain as to whether or not this document is part of or attached to that report.
Yeah.
That's what I was asking.
Yeah, I don't know if this was attached to, or all I know is this is a document that was admitted into evidence, and we've gone through many pages of it as part of the state engineer's file for each of the different permits. So I'll tell you, I don't believe it's attached to the geotechnical report. I think it's a standalone document, but I'm not going to tell you I've been through 370 pages to make that representation.
And I appreciate it. I think I was answering the clarification that Mr. Whittemore wanted. And I think with that representation that it's not a suggestion that that's attached to the environmental report.
All I wanted was to make sure that the record was clear that this was not probably a part of the underlying first page of the exhibit. And that's why I wanted the clarification. That's all.
And
Thank you, counsel.
And I'm making that representation to you, and I believe that's the case.
Yes, sir.
But
Got it.
I haven't looked at all the pages within the last few days. Okay.
In July 16th.
All right.
Thank you.
So let's start with this. Just a couple of points that I just want to just have you comment on. All right, we've already oriented ourselves as far as the date, May 26, 2005 is when it was received. We know that this is one of the progeny permits from permit 46777. And this is going to be, if you take a look at work performed right there, to the left of that, there you go. It's going to be for a new well. You
Yes,
see
sir.
that, Mr. Whittemore?
Yes, sir.
And then you can see what the proposed use is, and that was going to be for municipal and industrial.
Yes, sir.
So this would have been after the change in use application and approval that you had seen previously in questions by council today, right?
Correct. It would have had to have been because it has the permit number 70430.
Okay. And then if you'll just see the well construction, just right there,
Mhm.
you'll see how deep the well was, 935 feet.
Yes, sir.
Okay. Is that in your experience, a pretty serious distance to be drilling a well?
Yes, sir.
Okay. If you go down at the very bottom, left-hand side, you'll see that you'll see that there is a indicator there of how many gallons per minute were this well pumped, how many gallons per minute, 1,400 gallons per minute?
Correct.
Do you have any sense of just if that's a large amount of water for a well, an average out there at Coyote Springs, or do you know?
1,400 gallons per minute is good well.
Good. So under Coyote Springs permit, Coyote Springs / party, drill a well, well number one, and it's at a depth of 935 feet, and they hit water, a lot of water, correct?
It's good well. Yes, sir.
Okay. Let's now go to well number two, and that's going to be on 370. All right. Once again, we see the permit number, Mr. Whittemore, and would you agree with me? This is a progeny of permit 46777.
Yes, 70429.
Thank you. And you'll see again, if this is for a new well,
Correct.
and then same thing, proposed use municipal,
Correct.
right? And then we see below that CSI well number two,
Correct.
and we go over and we see how deep was this well? 1,019 feet, correct?
Mhm.
Once again, is that a pretty significant depth of for a well to be drilled?
Yes.
Okay, at least in the Coyote Springs Valley, based on your knowledge.
Well, just generally, I think that's a good depth.
Okay, and then you'll see, in case we
Excuse
did
me.
before,
It's a good depth because the requirements are that the water has to be taken from the carbonate aquifer.
right?
So you have to get through the water that's below the surface, whether it's 250 feet or 500, you have to get to a specific class of water. So it has to get to the carbonate aquifer.
And that's why you got to go so deep.
Well, you got to get there and you'll know.
And the
based
carbon
on-
aquifer is deep.
Deeper, correct, at this point, correct?
And if I didn't get the date, you can see the file stamp date there, bottom left-hand side there, right? You can see that it's July 3rd, 2006.
Correct.
And
Well, it says the report was 10/11/05 by Cat, but
Right.
the stamp on it was, yes,
looks like
July
the stamp, right, looks like the stamp was actually July 3rd, 2006.
correct, when it was submitted to the state engineer's office, but the time that they did it, the driller's certification was done in October 05.
Okay. So under this well, so this is well number two, and under another permit that Coyote Springs owns, and in connection with and partnership with Pardee, they drill a well over 1,000 feet deep and they hit water. And now the gallons per minute are 4,206 gallons per minute.
420.6, correct, right down at 82.
400, read that 420.6?
Yeah, I don't think it's 4,000.
You wouldn't get that kind of,
I don't know. I would have assumed it was 420.6. If it's 4,000 gallons per minute, it's even better.
okay, I'm gonna show you some other documents that may lead you to believe that there really were 4,206
If they
gallons.
If they did that for, well, it says that they did it for 17.5 hours. Yeah, might very well be.
Yeah. And that's, how would you characterize that kind of a well? At
Very good.
4,206 gallons per minute.
Very good.
We've reached our adjournment time. Tomorrow morning, we'll reconvene at 9:15 instead of 9.
Okay,
Thank you.
9:15. Thank you. Aaron.
Have a nice night.
Thank you very much.
Council,
Yes.
anybody want this?
Well, there you go. I don't know how many times I clicked over. I'm bumping my mouse here. Sorry, one-man show. W4Nevada Live. Thank you for tuning in today. My name is Matt Winterhawk, and you're watching the continued coverage of Coyote Springs LLC versus the state of Nevada and a $1.5 billion takings claim. Please do check in with W4Nevada.com. Follow us on all social media platforms, and make sure that if you have any questions, comments, concerns, or something we need to know, or you have a tip about it, anonymous or by name, either way, we're here for all 17 counties. Thank you so much. Carson, Churchill, Clark, Douglas, Elko, Esmeralda, Eureka, Humboldt, Lander, Lincoln, Lyon, Mineral, Nye, Pershing, Story, Washoe, and White Pine County. All 17, not just 2 in a sports book. And remember, folks, we're not just Vegas. Read the whole map. Thank you, and have a good evening, and we'll see you again tomorrow.
We're not just Vegas, you're not. Read the whole map, read it. Lights don't run the state, no they don't. That's a small cap, small cap. We're not just Vegas, look around. Past the neon haze, past it. 17 counties, all of them. Different lives, same place, same soil, same soil, same soil. They think Nevada starting in on the strip. That's like judging a book off the cover it get. Vegas loud, yeah, but that's just a slice. Plenty state left once you drive past the lights. This town's where a handshake still means something. Where folks know the land and the seasons are blunting. Where work don't trend and patience is learned. Where votes still matter cause people return. We don't all gamble, we don't all party. Some folks wake early, boots dusty coffee. Some places quiet, some places spread. Some rows long conversations with your head. The state breathe wide, not stacked in a frame. Don't shrink us down to a postcard name. We're not just Vegas, no way, no way. That service talk, surface, surface. Real Nevada, out here, outside the wall, outside, outside. This land where the sky feel heavy or blue. Where the silence louder than the news. Places built slow, no rush to impress. Where people still show up, not just express. Some counties keep food on shelves you don't see. Some keep water managed responsibly. Some keep the lights on, roads still paved. Some keep the history from getting erased. Not every voice come with billboards and sound. Some carry weight just by sticking around. We don't move fast, cause we plan ahead. We don't burn bridges, just to feel said. Nevada ain't one tempo, one look, one lane. It's contrast stitched into the same terrain. We're not just Vegas, past the glare, past it, past it. The state move quiet, steady, everywhere, everywhere, all around, all around. If you move here, welcome, just learn the pace. Respect the ground, don't rush the place. We don't copy cities that couldn't hold. We're not just Vegas, yeah, nah, yeah, nah. Read the whole map, read it, read it. Lights don't run the state, no they don't, no they don't. That's a small cap, small cap. No, we're not just Vegas, look around, look around. The neon haze, past it, past 17 counties, all of them. Different lives, same place, same soil, same soil, same soil.